Mr. J. Islam, the learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated. (31). 31. Yes. You've taken the consent. Okay. Item number 31 to be listed after 6 weeks. Consent?
Yes.
It will be listed after 6 weeks. (18). Mr. D. Chaudhary, appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
I'd like to mention item number 44.
40?
44.
44, yes. Why? That's an I. I for what?
I seeking 1 lakh.
Why? Why the I has come? Oh, you don't know. Don't mention. We'll see when the matter comes. Next.
Mental items for 8 and 9.
Yes.
By Mr.
Item number?
8 and 9.
You want an adjournment?
Yes.
Why? Why?
My senior will come to I of us.
Who is your senior?
Yes,
Huh?
yes, yeah.
S.A. Ahmed. He's the most junior most amongst who? 2015 matter. No adjournment. Sorry. We'll see why the matter has come.
I said.
I can't help it. It's a 2015 matter. Sorry. We'll see. I'll help you. Next. No adjournments. 20. Yes. When? Stay. Interim. No adjournments. Hmm. You're not pressing. Your name? And so appearing on behalf of the petitioner submits that he has instructions to withdraw the writ petitions, and accordingly the writ petition stands closed on withdrawal. Interim order, if any, stands vacated. Protector Belek order deputy.
41 to 43. 41. Number 1 promotion.
I can't hear you, madam. Speak up a bit louder. You want to withdraw? Close as well. Withdrawal. The learned counsel appearing on behalf of the petitioner submits that the grievance of the petitioner has already been taken care of by the respondents, and as such should not like to press the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Item number 2, what are implement the party?
Who are you? You are the son of T. Narayan Singh. Yes, then what is the repetition, Mr. Samaria?
The petition order has been cancelled without forwarding opportunity of my lord hearing. That is the crux of the thing. We have to-
Mutation order of yours was cancelled without giving you an opportunity.
That is the sole issue, the rest matters doesn't solve.
And what do you have to say about them?
My lord, if it may, I know that.
And how, means their names have been inserted.
My lord, they are not, they are also the claimant on that. That because once my name has been deleted, my lord, they would claim that. That's why, my lord, they would- If my name would be, that my name has been cancelled, now they want their name to be included, my lord, that is their, my lord, basically.
Okay, they were cancelled. Your name has been cancelled at their behest,
Yes.
and you have not made them a
Not
party.
their- Not their yes, my name was already there. I have been, my name has been cancelled.
Why?
My lord, they are showing a reason that because the degree has passed against about my status, my lord, adopted son. Based on that, my lord, they approved it for the GMC to cancel my mutation order. Earlier which was granted.
So the GMC has cancelled it.
Cancelled.
Why haven't you made them a party?
My lord, the reason there is that so far their concern is concerned that would have been, they are not the concerned person.
Why? On one hand, you are saying that the mutation has been cancelled at their behest.
Yes, yes. Now they are claiming one because my adopted status has been, my lord, order was passed against me by the civil court. My lord.
Understood?
Now, so far there is two persons.
So they say that their name was, that your name had been cancelled, or the mutation in respect to the property of yours was cancelled at their behest.
No, absolutely not, madam. I make the position here, madam. I am the adopted son of X, madam. Now, I am the adopted son of X and the person whom they are depending, the father is the husband of X, they are claiming so. Now, my mutation was granted to me in the name of X, madam, being adopted son. Now, subsequently, adoption, suppose that the status they have put on the children, that has been supposed set aside to the civil court. So therefore, since they are the son of the husband of X, now they would like to inflict there.
No. The instant application had been filed by the applicants seeking impleadment in the accompanying writ petition on the ground that any orders which would be passed in the writ petition would be prejudicial, would act in any order is passed in the writ petition, the same would affect the applicants. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, submits that he has no objection in pleading the applicants as respondent numbers 4 and 5 to the writ petition. In that view of the matter, the instant application stands allowed by pleading the applicants as respondent number 4 and 5 to the accompanying writ petition. The registry said, the petitioner, you file an amended memo. The petitioner is directed to file an amended memo of parties within 7 days from today before the registry. And the registry shall, on the basis of the said amended memo and the order passed herein, shall make necessary changes in the cause title and also update the same in the CIS. IA accordingly stands disposed. Now wait, main writ petition. Miss, your name? So and so, appearing on behalf of the repetition on behalf of the newly implemented respondent number 4 and 5, 6 for an accommodation for filing their affidavit in opposition. You have extra copies. You have copies of the petition. And have you filed the affidavit, GMC? Yes, GMC. Who is appearing for the GMC? Okay. No. None appears on behalf of the GMC on call. It further appears from the records that the GMC have also not filed the affidavit in the matter. Taking into account the above, list the matter again on tenth of January 2024. The GMC as well as the private respondents are directed to file their affidavit by 5th of January 2024. The petitioner, in the meantime, would be at liberty to file their reply thereafter. The interim order passed earlier shall continue till then.
What about TL4 for admission?
After they were idea property was kind of referred by river erosion affected. If you consider the an exact activity, that is page 51.
Page
51. Right? An enforcement case was registered.
You are occupying in grazing reserves. It has not been reserved.
Not yet, madam, to my knowledge.
So there is no question of allotment of this land to you.
So, madam, what I have submitted, madam, in my reply affidavit to their affidavit, that there was a policy, madam, for settlement of these people, madam, only for those who were.
No, you may apply for settlement in some other place. That's a different aspect of the matter.
Exactly. I'm
But
not
you
saying-
cannot seek for a settlement out here.
saying, madam, that
So you do one thing, you apply. In the meantime, don't disturb them till your applications are disposed of. I think that is the only way.
Not many, madam, 70 or 80, madam. Let them file individual application.
Obviously,
Yes. Oh,
within 30 days, you have to file your individual applications. What is the other one? Who is appearing for the other one? Itu belek ke hoga. Itu pertama itu. Item number 3. The instant writ petition has been filed by
it is not what I raised about and so many of the persons themselves are also here.
filed by 13 petitioners, being agreed by notices issued to evict the petitioner number 2 to 13 by the circle officer, Bagbor Revenue Circle, dated
Please.
30/12/2014 in various encroachment cases, in one encroachment, in respect to encroachment case number 4/2006/07. Also. It is the case of the petitioners herein that the petitioners are landless. What is it?
River erosion affected by.
Are river erosion affected persons
I've given the certification and next one.
and
Is
they are entitled to settlement over the land under their possession. And as such, the petitioners have approached this court challenging the said notices. Mr. N. Goswami, the learned counsel appearing on behalf of the Revenue Department of the Government of Assam,
I want to clear.
and appearing on behalf of the respondent number 2, 3, and 4, submits that as per the government policy of 2019, government's land policy of 2019, as well as also the judgment of the Supreme Court in the case of Jagpal Singh versus so-and-so, reported in so-and-so, State of Punjab, reported in
2011 SCC.
so-and-so. The question of settlement of the petitioner over the said lands does not arise inasmuch as those lands have been specifically earmarked as village grazing reserves. Mr. B.T. Goswami, the learned counsel appearing on behalf of the petitioner, submits that although the petitioner may not have a right to get the settlement over the land presently under their possession in view of the well-settled principles of law laid down in the case of Jagpal Singh Supra, but the petitioners, being erosion-affected persons, are entitled to settlement of government wastelands to which the petitioners may be given the liberty to file individual applications within a time stipulated, and the petitioners should not be disturbed till such applications are disposed of.
I also relied on their certification that is next page 9 of my reply application. They had this is a scheme I got. In 2016, my statement is a special scheme for rehabilitation of erosion affected.
No, now it has been taken over by the land policy of 2000. After hearing the learned counsels for the parties, this court is of the opinion that a question of interference with the notice impugned in the instant proceedings does not arise inasmuch as the petitioners herein have no right to remain in possession or even get settlement of the land which have been specifically earmarked for village grazing reserve. Be that as it may, the petitioners, the materials on record clearly shows that the petitioners are erosion affected persons and as such would have been entitled as per the government policy, land policy of 2019, for seeking allotment, settlement of government wastelands, provided they meet the eligibility. Accordingly, this court therefore disposes of the instant petition, thereby granting liberty to the petitioners herein to file individual applications before the deputy commissioner. Deputy commissioner, where? Deputy Commissioner Borpeta, District Commissioner Borpeta,
District of,
Borpeta, within 30 days from the date of the instant order, as per the provisions of the land policy of 2019, full stop. The respondent authorities, that is the District Commissioner Borpeta, as well as the Revenue Department of the Government of Assam, shall duly take notice and duly consider such applications as per the said land policy. Full stop. It is further made clear that till the said applications are not disposed of by the respondent authorities, the respondent authorities shall not disturb the possession of the petitioners in disturb the possession of the petitions. With the above observations and directions, the instant petition stands disposed. Equally, vivo, none appears on behalf of the petitioner on call. Accordingly, the petition shall be dismissed for non-prosecution. Put your date, name.
5 and 6. What's it? 5, 6, and 7.
Yes, what are these? After notice, it has come for the first time. Why? Does anything remain? Huh? What is this?
The petitioner purchased some plot of land from the respondent of a case. And the execution process was done. And the key receipt, is the case 19 was also issued.
Hmm.
19 was also issued. But the original sale deed was not released.
Huh?
Original sale deed was not released.
Not released?
Not released.
You got the receipt
I got the receipt.
till now.
Until now, original sale deed was not released. In fact, what happened was in the year 2011, the sub-register of the area
Ah,
was in the perform. Registered some sale deeds without getting the sale permission.
okay.
So therefore, on 16/5/2011, the circle officer of that area lost an FIR. Which is the case 22.
Then
On the basis of this FIR loss,
you got the certified copy.
no, nothing was done.
Then
And for that time, not 2009,
I'm impleted. What is the stand that is so and so, and as per the deputy commissioner letter dated on sealed and the courts were sealed by the so and so. And the police state the certified copy of this could not be given as it was seized by the police on the Hosai police station. Now what happened? This is the old time thing.
now the government has taken the decision that they want to regularize it and they want to release it. There is the decision of the revenue department is also.
Yes, yes.
Let's show you page 29.
Mr. Gusami, what is all these things? What business you have to keep those sale leads? Huh? Get your instructions. We'll have it on Wednesday.
Other two items are there. Money receipt was not.
Then
Then
what?
number 5 and 7.
Then how do we know? Okay, anyways, get your instructions by Wednesday, for Friday. We'll have it on Friday.
Last petition, it was stated also, due to tendency of a criminal petition. The same was not.
No, that is a different thing. The fact that these are sale deeds executed between two persons, maybe without a permission also, can the sub-register say that we are not going to release it? The sale deed may be wrong. The sale may be illegal. For that, what is, you see, permission is required from whom? These are where? Where are these?
Hosai.
Hosai. Now, these permissions are required. These are without permissions. So this is done under 21A. 21A. So 21A says that there shall not be any, that no sub-register or registering authority shall register without it. Now, once it is registered, then what is the consequence of it? Get your instructions Friday. List the matters on Friday.
Yes.
On which date Mr. N. Goswami appearing on behalf of the District Commissioner?
Hosai.
District Commissioner Hosai shall obtain instructions as regards the sale deeds in respect to the sale deeds in question in respect to the petitions, in respect to the petitions in respect to the 3 writ petitions.
8, 11. October 8 and 9.
Yes, why two matters together? 2 matters, 3 matters together. Yes, oh, this matter.
Yes.
Yes, tell me.
And the pilot is-
Don't worry, we'll see what can be passed. Not to carry out the works over the petitioner's land and to evict the petitioner from his land in possession and settle the land with the petitioner for payment compensation for the land in possession of the petitioner which have been acquired by the government falling under tag number 25 under Barnihart so and so. Yes, what is your instructions? You are to obtain only instructions as to what the payment has happened or not. Friday. Friday. With eyes or no eyes. Friday. Okay? List the matters on Friday on which date Mr. N. Goswami shall obtain the necessary instruction as regards the acquisition status as well as the compensation which have been paid in respect to the acquisition proceedings.
October 10 and 11.
Yes.
Here, the standing on notice of eviction.
Huh?
Notice directing us to vacate from the premises. At page 27 is that notice. Now, this was under the apprehension that the locality in question is prone to landslide. And it's since it's a hilly area, therefore I should vacate within 72 hours. Otherwise, my lord, I'm the owner, my lord, I have the permission from the GMDA, buildings have been assessed under the GMC. Everything is in place, my lord. Just the fact that the circle officer found that the area is prone to landslide, therefore I should vacate lock, stock and barrel within 72 hours, no rehabilitation plan. Now, my lord, now, one thing is clear, my lord, the 2015 matter. And one thing is very clear that the apprehension was not correct. Nothing has happened so far, my lord. So the apprehension was not correct, my lord. That is something which is apparent. So now, my lord, of course, it's a genuine concern, my lord.
Where is that land located?
Hardly
Kharguli where?
on the property Ramsar itself.
Ramsar Hill is a big plot of land. Where?
Exact location is when I'm not aware of.
Fantastic. We are on the location business and you don't know where the location is?
They are occupying the Government land.
These are government lands.
No, okay, it's a lot. Fine, sorry. No.
No, no, no.
Here is a government land. It is like
My name is Manoj, I have,
Petitioner number is what?
four. It is something. Sorry.
Pradeep Das.
It's below four.
Have been found highly vulnerable to landslide which may threaten not only the life and property of FI but also several others here. So what is wrong with this notice?
Manoj, all said and done, Manoj, the authorities as per with the requirement of.
Did you take the permission in building the house?
Yes.
Show me the
Manoj, page 20.
page.
20.
This is for transfer. This is not for building.
Put it there, sir.
Huh?
It is put it there, it's put it there.
No objection is for this 22.
Sorry. 23, 20, 22.
Have you made the GMDA a party?
No, no.
Why?
Manoj, because the notice in question was issued by the sub officer and
No,
the.
no. Why should this court interfere with these type of notices? This is not a court to interfere with these type of notices because this is the question of if it is it's a hazard to your life and your property. Obviously, this court is not going to
Therefore,
act as an expertise out here.
Manoj, I agree with it. Therefore, my submission today is from 2015, Manoj, they said it is so urgent, nothing had happened, so their apprehension was wrong. Now, from 2015, we are in 2023. All I'm saying is, Manoj, let there be an assessment, and if they suggest some corrective measures that I will need to put up a retention wall or something, Manoj, they can advise me, I can do. Because this assessment was made in 2015. Now, let them assess it on the ground, and if they find that certain corrective measures are required, I may be advised accordingly. Manoj. Because otherwise, my lord, there's no dispute regarding my title, my lord. State authorities have given me permission, my lord. These are
Here you have been only asked to vacate.
My lord, vacate within 72 hours. This is a residential house, my lord.
Maybe, but if it is located in a place which is dangerous, tomorrow, just for example, there's an earthquake. I mean, probably it doesn't happen, but an earthquake happens. And this building becomes used, you cannot use the building. And a notice is being issued by the disaster management department out there to the say that kindly don't. If this court going to interfere under 226, then that is the reason why this has been done. Why should this court act or in any expertise out here?
No, I'm not ready.
You have you given any certificate out here that irrespective of anything, nothing is going to happen out there? Give me a certificate. You produce a certificate to that effect. Next this Friday, by Friday you produce a certificate. Nothing is going to happen to this building. Okay, very well. Who is going to give a certificate? Nothing is going to happen. Then why this court under 226 should interfere? This is not a case for which this court is going to interfere.
There is nothing on record, even of the affidavit to show that there were materials to suggest they had carried out an inspection or anything of that sort. So all I'm saying today is, let them visit the
Why?
location. Let them.
Why you yourself don't know where is the location? That is why I asked you where is the location. You say Ramsay Hill. Ramsay Hill is too big an area. Then
One of the lanes where I.
what you can't make this the type of submission out here. That is why the first question I put, where is the location? No, we dismiss it.
First.
This court under 226 is not going to look into all these things.
They already filed the affidavit.
You approach the authorities.
Just 2 points.
What affidavit they have filed? Let us see.
Was filed on 27th of May.
That a petitioner have been verbally apprised of the vulnerability of the residential location many times prior to issuance of the notice, and hence they were aware that they would have to vacate the houses sooner. And many deaths have occurred during monsoons as a result of the landslides. The concerned department will definitely take corrective measures as per the provisions of law, but in order to avoid any mishap such here.
So, if there a report, my lord, that my particular house is posing risk, I understand it's a genuine concern. But there has to be some basis, my lord. Either state authority, another.
That
state-
basis, this court doesn't find any basis to interfere. I don't find any basis. Why should this court exercise 226 in this
My
matter?
lord, this is in fact my right to property, my lord, I'm. looking-
Not right to your property. If it is not in a, have you given any certificate that it is, it is, the feasibility certificate about the land that nothing is going to happen? No, this court is not going to exercise 226 just for the sake of it.
My lord,
You have to show us by way of it. The affidavit was filed long time back. It's on 2020. Why haven't you just given a reply to that effect?
petitioner expired and-
So that means, whether if the petitioner has expired, nothing is required. Nobody is there. Of course. So legal head is there, then why the legal head has not been, have not filed the affidavit bringing on record a feasibility certificate? My goodness,
Then
this is the case of where the, what do you call, the,
whether they have been an objective assessment or not, whether.
not necessary.
whether they have.
Why should this court at all look into it?
Because-
There, you have been duly informed about this thing
Well, verbal-
earlier.
Verbal information, my lord, will that be sufficient? I'm sort of thrown out from a residential house where I have all the requisite permissions.
So for that, you should have produced some certificate to that effect, that yes, because of this, you could not have formed an opinion.
Because the GMDA has a zoning plan.
No, no, I'm not concerned with the GMDA. Why haven't you made the GMDA a party there?
The GMDA has already issued the permission.
Forget about that. You should have. On one hand, if you want to take the advantage of that, why haven't you made the GMDA a party? You should have made a party, GMDA a party.
And make them a party.
No, for that I'm dismissing on the ground of that. You are not implementing the right person. Are you making, you should have, if you are insisting upon that the GMDA has given the permission in a proper manner, then obviously you should have done it. This is not a case by which this court is going to exercise 226. You approach those authorities out there. Ask the authorities for feasibility certificate and whatever may be, but this is not going to.
On the ground of natural justice. or-
What natural justice?
But no notice, nothing.
What notice, what notice is required? Tomorrow the building is going to collapse out there because of the rain, and tomorrow you are going to again come back and ask for compensation because of that. Not a
On the
case.
ground.
There's no equity out here. Equity is dependent upon the facts. Here there is no facts out here to provide any equity for you.
At least ask them to carry a subject report whether.
For what?
Regarding the status of the building, the vulnerability, my lord, if I
No,
did.
it is you. You want this court to exercise 226. Then why it's not their burden. It's not their burden. You say that yes, my building is fantastic and fine. It is nothing is going to happen. And there's as such interfere with their notices with notice which have been issued. That's your case. Then show us something to that effect that yes, nothing is going to happen, that would be our conscience. This court will pass the order.
I'll try to.
Wednesday,
But, 2 days.
Wednesday, enough is enough. Wednesday.
Friday.
And let the list the matter again on 14th of November 2023, on which date an opportunity is given to the petitioner to produce any feasibility certificate as regards a feasibility certificate as regards the building standing on the location is as regards the building standing on the location. Stating inter alia that there, feasibility certificate that the building of the petitioner standing on the location is neither causes any threat to the life and property of the petitioners as well as the neighbors.
Well,
And Mr. Goswami, you get your instructions. Mr. N. Goswami shall also produce the obtain instruction as to on what basis that the impugn notice was issued. None appears on behalf of the petitioner on call. It further appears that on the earlier occasion also the petitioner was not represented. Taking into account the above, it seems that the petitioner is not interested in the proceedings for which the instant petition stands dismissed on non-prosecution. Interim order, if any, stands vacated.
Patel,
Compensation for what? Huh? Then?
Now, election, the process is one in the district election, it happened in the year 2016. Compared with the persons who have been deciding that since last 30 years, and they with something constructed dwelling houses and other establishments over that land.
Oh, you may get your right over on Zirat, not on nothing to do with the land.
Also, under the lordship, the government has finally indicated the Highway Authority of India has already deposited compensation. It is reflected in the affidavit lordship, affidavit filed by restaurant number 5. Some of the petitioners are.
Will there be, yes.
The-
Rule 3C of the affected person who does not have land or imam has the right to claim for compensation against the affected structure. Accordingly, against knockout and dark number, 3C will prepared and submitted to the colony to the and received the applications of the court to stay the form. With the banks to stay the during this Many petitioners have received compensation.
Some of them.
Origin them sent to NHDCL for necessary action on disposal of the same complaints will be duly or to the affected and the additional weeks per day of the subject to implementation of the public. There is no representation in respect to petitioner number 1, 24, 26, 32, 40 and all.
Other petitioners received some being compensated.
What is the status of compensation? Yes, that is what I've read it. Huh? This affidavit was filed in the year 2019. What is the status? Mr. N. Goswami, appearing on behalf of the respondent number 5, shall apprise this court as regards the status of the acquisition proceedings as well as also the compensation payments so made pursuant to the affidavit filed by the respondent number 5 on 27/11/2019. This is the matter again on 15th of November 2011, 2023.
Respondent what he has filed that and everything of your medicines.
14,
It reveals on the records that the petition, it reveals on the records that the petitioner had expired, petitioner number 1. None appears on behalf of the petitioner on call. List the matter again on 10/11/2023. It is made clear that if the petitioner is not represented on that day, the instant petition shall be dismissed for non-prosecution.
51, 16.
Yes, what is this? So what? On the last occasion, you did not appear.
I was not aware of that.
Then
Because, on the next particular time,
what is that? Hey,
Southern sister evening at 4 o'clock.
Yes, what do you want?
Any detail, please, that I will open the instruction.
This is a very old matter, Mr. Counsel. It doesn't look nice that you are asking for an adjournment. Why? What is there to ask for an adjournment? You have a case, you can, no, if you have a case, say, what's the case you have?
Petitioners are the mother and daughter, and against the brother. So.
Why are there two petitioners? Why are there two petitions?
Petitions kind of to, whether orders your partner, will get that the orders. First of all, I guess, in the meantime, or another.
Okay, let us see, 55851. So petitioner is,
I'm saying that, only one day.
no, okay, I'll give you a cost of 10,000.
No,
At the request of the learned counsel for the petitioner, matter stands adjourned. Huh?
I was not aware the earlier time.
So what? Why are you keeping these type of matters pending out there unnecessarily? If you are not willing to do the matter, then why are you keeping these matters pending?
I want to open the instruction.
What is there to obtain instructions in this matter?
Infrastructure on document, right?
What is there to instructions or not? We'll have it too. Get your instructions. Go for it.
17.
Yes, madam, what is this? Notice, section 18 notice. What is your right over the land? Where is the notice?
Notice at page 13,
Page 30.
1 and
1, 3.
13 is the translated copy. And exactly.
It is general notice for all concerned and directed to the all incumbents to vacate the government reserved land on 15 on the national highway under Iman, hence under section Iman shall compel for eviction. Then you gotta stay. You are in occupation of government land.
Rented basis.
Whatever may be, madam, but whatever may be, does your person with whom you have entered into, that is Mr. Bhupen Chandra Buro, is the owner of the land? Show me that. Show me that.
Agreement rented.
Rent agreement could not do it. You have to show you are a tenant of Bhupen Chandra Buro. So they say, huh? I have seen it, page 17. That is the agreement between Bhupen Buro and you. Show me that Bhupen Buro is the owner of the land. Where?
I am not paying for the office for the landman. I am paying for the office for the materials that that I own. The shops are not mine. they have demolished all my,
They've already demolished. They've demolished your house. Then,
and even on my mobile shop, mobile and other.
no, but what is your prayer? Madam, what is your prayer? Let us see. Kindly come to page 10 of your requisition. You are asking for setting aside and quashing the notice dated 29/4/2017. Now that notice has already been given effect to, so nothing remains. That is page 13. You have been already evicted. So prayer number 1 is no longer there. Now come to prayer number 2. Directing so and so to release the due compensation amount to the petitioner after eviction done under notice dated so and so, and direct the respondent here to provide alternative way of the petitioner after eviction under section 18. What compensation?
One is, for
How can this compensation question be decided here, madam? Tell me, no.
without giving any, without giving, without informing me. Without informing me the notice has been served. And notice was, sticked on the.
No.
top side.
Under rule 18, is a notice required? No. Understood. So the demolition has already happened. Now, how much compensation you are entitled to? How can this court decide?
Same for the companies, only for the materials, my lord.
Okay, whether there were materials or not, how will this court know? Tell me. Isn't it the case of in the civil court?
Yeah, we will go, no, my lord.
Yes.
We went to the DC, we have submitted the representation before DC.
No, the DC was, if DC does not do anything,
You-
Huh?
you-
fantastic. The Prime Minister would help you out, you go there. Why you are before this court? Huh? Nobody can help you unless you go to the civil court. You see, you have already been evicted, so the prayer number 1 is gone. How much compensation you are entitled to? This cannot be decided by this court. You have to go to the civil court. Now, the incident with petition, the petitioner herein is a tenant of one Bhupen Chandra Bora, Boro. And was engaged in the business of mobile repairing and electronic goods. The circle officer, Bipuria Revenue Circle, Bipuria, had issued a general notice on 29/4/2017, directing all illegal occupants of government reserve land to vacate. Pursuant thereto, the petitioner was evicted and it has been alleged that on account of the eviction, the petitioner had incurred huge losses. Accordingly, the petitioner herein had filed a petition challenging the notice of eviction dated 29/4/2017, as well as also seeking compensation for the loss incurred by the petitioner. on account of the eviction. This court have duly heard the learned counsels for the parties. As regards the question of challenging the notice dated 29/4/2017, the same having already been acted upon and the petitioner having been evicted, the said challenge to the notice becomes redundant. The second aspect in the petition is as regards compensation, which the petitioner claims on account of the loss suffered by the petitioner on account of the eviction. The question as to how much loss the petitioner has suffered and as to whether any loss has at all been suffered are questions of facts which this court cannot adjudicate under Article 226 of the Constitution. The petitioner would be well advised to approach the civil court to claim such compensation if deemed fit. Accordingly, this court is not inclined to exercise its jurisdiction under Article 226 of the Constitution for the reasons aforesaid, for which the instant writ petition stands dismissed. Be that as it may, this court, however, observes that the dismissal of the writ petition shall not bar the petitioner to approach the appropriate authority seeking compensation, if so otherwise permissible under law. With the above, please.
19.
Yes, what is this? Photographs and all. Inaction on the part of the to protect the compound wall of the petitioner, removing illegal and unauthorized structures. Yes, Mr. Nayak, what have you done? Should not be issued directing the one to protect the boundary wall of the petitioner, removing all illegal RCC building, other structures, unhygienic latrines, so and so. Reply was filed when? What is the reply? Yes, Mr. Nayak, so what is your reply?
They are paying for filing reply to our reply.
Understood. What is your stand?
The affidavit we have stated that one portion of the building the owner has already been paid. He himself has. And
He.
no, not the owner of the building.
Who is he?
He is the petitioner. They were.
Okay. Kindly come to annexure A of your petitioner. This is a photograph, latrine, urinal, washroom on and near to the boundary wall of the petitioner. This is the wall. Now this wall has been demolished. This wall remains. Now what is your prayer in the petition? You are saying that should not be issued directing the respondent to protect the boundary wall of the petitioner, removing all illegal RCC building. Which is the RCC building you are referring to? This one, annexure D. Oh, Disputes, family dispute, neighbor disputes. No, the petitioner's uncle, kindly see Annexure D. You have a copy of the petition? See,
Uncle is not the party lot, they are also affected.
no, RCC building near to the boundary wall and semi-RCC house of the petitioner's uncle.
So that the other party is party, other party is and property of the petitioner as well as of the uncle is affected.
And petitioner's uncle is not here. He is not agreed.
He already accepted.
Okay, fine. Now,
So far as that.
now what are you having? This type of houses, if it is there,
That illegal portion, the petitioner, the other side has already.
who is appearing for the other side? Private respondent who is appearing?
Whereas that toilet is concerned of that is under silver.
Oh, private respondent is not a party. My goodness. Mr. Counsel, how are you going to maintain? Somebody else, has the GMC constructed? You want the order of demolishing of somebody's house through the GMC. You are not making him a party? Forget about the affidavit. I'm not on the affidavit. Without the affidavit on your petition itself, I'm saying. How can you maintain the petition? You are asking that this court direct the GMC to demolish the house of somebody else and the somebody else is not a party. What? Is it possible to entertain this petition in this manner? You should be happy that the petition lived for 4 years. You have taken that ground? No. But how is it possible? Tell me. Can this court pass an order directing you to demolish the house of somebody who is not a party without hearing it? Yes, Mr. Counsel. For what? Reply? Forget about the reply, your petition now. Your reply will come when your affidavit is there. Yes, Mrs. Burman. Kindly come and help your counsel. Yes. How are you maintaining your petition? Tell me. We will close our eyes that you are an additional senior government advocate and then take it as we are appearing as a private individual. Huh? Wait. Yes, Mr. How are you maintaining your petition? You don't know your neighbor? You don't know the name of the neighbor? Isn't it the strangest thing that you don't know the name of the neighbor? It can't be. Have you mentioned in your petition you don't know the name of the neighbor? Show me. How is it possible?
Initially, we are also on the conclusion of the landed government and cost. Subsequently, it was called a gate, but then both the affairs are made.
Therefore, at best, you may only go into the question of setbacks.
Yes.
Or any illegal construction
So,
which has
illegal construction is already taken.
we have already taken action. But how can this court pass an order without putting them to notice? And there is no mention out here that the petitioner does not know or could have, after due diligence, could not find out the name. You say that some unknown persons have made the construction. That can't be that. Then also you know the name now. Then why haven't you made them a party? The learned counsel for the petitioner seeks for an accommodation of a week for filing an application to implead the private respondent, to implead the person against whom directions have been sought against the persons who as per the petitioner have made illegal constructions of the buildings. This is the matter on 2011-2024-23.
Number 20.
Huh?
Otherwise, the lease is already.
Setting aside and quashing the impugned order issued by the AR cancelling the agreement for parking stand of
Otherwise, the lease is over.
then what remains? My goodness. Lease is till when?
31st of January 2020.
Where is it?
So it was executed on 1st of February 2019, but it page 17. The date of the platform.
Lease is valid for, and after 3 years, both will make another agreement if necessary. Okay. Period is over. The council appearing on behalf of the parties submits that as the lease period in terms with the lease agreement dated 1/2/2019 had already expired on 6/2/2022. Nothing survives in the writ petition for which the instant writ petitions had become infractions. Taking into account the above submissions, the instant writ petition stands closed as infractions. Interim orders, if any, stand vacated.
21.
Yes, Mr. Triple S Rahman. Yeah.
Number 1.
Yes.
My son died in in Guwahati. And we love postmortem was done. We got a big and the school came
This is for MDR page. Which one do you want? Payment 4 lakhs. Ex gratia to families of deceased person involved in relief operations or associated in remand subject to certifications regarding cause of death from appropriate authority. You are in relief operation. You are claiming under 1A.
Yes, sir. My son died having Guwahati.
Due to flood in Guwahati also you get it.
Yes, sir.
Where?
Please,
13?
Yeah.
13 which number? Serial number?
Number 1.
4 lakhs per deceased person, including those involved in relief operations or associated in preparedness activities subject to certification call of death from appropriate authority. Yes, where is the certification?
Please, my lord. Please, my lord. Please, one.
Hmm?
Please, one.
What? This is a postmortem report.
Yes, sir.
Is that a certification?
He was there when he was speaking of his photos. The report of the
You have?
report of the
Hmm.
was
river. Then,
By the river, it's wrong at that.
or then also you pay. When do you pay? Because your government seems to be very generous. Oh, that day I passed an order on that public places. You see, the definition of public place, which was there at that point of time, I have not accepted that. The reason is, if you see the Supreme Court judgment, there is a one judgment. You see, what is the term public place and public place in view? There is a difference. Your earlier notification, which I said would only be constricted to the earlier notification, included public place in view also. But the Supreme Court in that judgment, which I have referred to, have changed this, have differentiated that aspect of the matter as to what is a public place and what is a public place in view. Just for example, for me, that is a public place in view. And for you also, this will be a public place because you can view it. So that is the reason why I say no, it can't apply. You may have it in there. The government can always give it. That is why here also, do you give in that such type of things also here? Then, ah,
For me, why not, there has to be, one has to come within the, at least of the estimation of disaster. There why not specify the-
yes, that is what I am saying. It has to come within the ambit of disaster. And the boy, how did the boy die? The final report is only drowning.
Why not-
Taking away from the-
That is to put in the form of an.
Yes. Why don't you file affidavit? When? File the affidavit by 2011-2023. List the matter on 2011-2023. Mr. N. Goswami. And the circle officer, which one? Dispur Revenue Circle is directed to file an affidavit by 16th of November 2023. Similar order does not work so properly at all times. Similar orders are dependent on facts.
22.
Yes. Ex gratia. 2 lakhs. How did you die? Where? Huh? How did you die? Police report so and so died on 2018. Was riding motorcycle bearing from so and so nephew reached so and so direct hit to Rimban and disposed of. It was 3 months. I go to the naam ko likhi and review.
Mayor, with your worship, my lord, in this matter, the IPDCS has filed an affidavit, my lord. I need 2 weeks time to reply, my lord. And my lord, MNR is the government of India, my lord, they are also required to file affidavit. The issue is that, my lord, the petitioner performs some contractual job under the APDCL. So they have to receive some amount from APDCL. And APDCL is stating that they have to receive some amount from MNRE, Ministry of New and Renewable Energy. So that fund have not, they have received. That is the main issue. So the affidavit of the MNRE is also required. And we will file a reply to the affidavit and by the APDCL.
Actually, Mr. Speaker, I have received an instruction long back in November, November 22. And that, they stated that, though it is not a paragraph, instruction that judicial authority has not submitted that on the document till it is November 22. And because of that, they have not released the fund, and the project was of 2007, 2009. So, after a period of time, they have not provided the document. Now they have come with an affidavit,
in a affidavit we've already provided.
Now, they have given a copy of the affidavit, I will send this, affidavit along with this, to latest instruction, I have not seen this. At least 4 weeks time.
The instant petition has been filed by the petitioner claiming an amount of rupees 1,88,47,331 from the respondent number 1 and 2 in terms with the memorandum of settlement dated 9/12/2015 along with interest. Pursuant to the filing of the writ petition, an affidavit in opposition has been filed by the respondent number 1 and 2 on 9/3/2022, stating inter alia that the petitioner is entitled to the said amount.
We raised preliminary objections.
Yes.
Firstly, madam, the amount itself is now time barred. Now what they are essentially seeking is enforcement of a time barred case. Because the agreement is of 2015. The agreement stipulates that the payment has to be made within a period of 90 days thereafter. One portion of the payment of 2 crores was made. 1,88 lakhs was contingent on the MNRE paying the APDC. That amount was not paid. Now the writ petition has been filed in 2021. Seeking enforcement of that MOS of 2015, even though the limitation period has ceased to exist.
Apart from the limitation, are you admitting the amount?
The amount otherwise is admitted. The fact is, whether they
Had filed an affidavit in opposition on 9/3/2022, raising preliminary objections as regards the maintainability of the writ petition on the ground of limitation. However, it is an admitted stand that the said amount of rupees 1,88,47,331 can only be paid by the respondent number 1 and 2, provided the same is disbursed by the respondent number 3.
Ministry of Revenue and Renewable Energy.
Respondent number 3. Mr. K.K. Parasar, appearing on behalf of the respondent number 3, submits that he had received an instruction to the effect that the said amount could not be disbursed to the APDC respondent number 1 and 2 on account of the respondent number 1 and 2 having not placed the requisite papers for disbursement. Mr. Your name? B. Chaudhary, the learned counsel for the APDCL, however, submits that all such requisite documents is a part of the affidavit filed by the respondent number 1 and 2 on 9/3/2022. Mr. K.K. Parasar therefore submits that he needs an accommodation of a period of 4 weeks so that he can obtain the necessary instructions in that regard. List the matter again on 11th of December 2023. In the meantime, the respondent number 3 shall file the affidavit by 7th of December.
25.
What is the amount? What is the case? State disaster. How did you die? Huh? Drowning where? Flood. Flood where flood? Which flood?
Police report, address 16.
Hmm?
Police report, address 16. Incident, 2% had died. One is got really bad.
Huh?
1 person already victim.
You went for fishing. in the flood.
Yes.
And you drowned. Huh? Then you took the risk. Police report says he did about 13 years, went to fishing in a pond from their houses and drowning over the water, causing that they died. Fishing also you get.
He's a professional fisherman.
And you are paid.
I am inviting the building myself.
Understood. That is what. This is the police report. No, police report says he went for fishing and then he drowned. Tell me,
I was stuck up in the house, last came, was coming.
Ah.
That was happening in another kilometer. I invited my own ferry.
your parents should be compensated, you should compensate the state. Huh? The petitioners. The son died, na?
Husband,
Husband,
husband of the.
13-year-old. Police still a
that
police
is
report.
another person. I think not the son, different. That's document. And
You are referring to page 16? Page 16 is 13-year-old.
13 years is the son, that is different person. Or this is name is the middle remedy. That is the husband of the.
I think that on Iman at about Iman, my younger brother, namely Midul, and his cousin, namely Raktim Medi, age 13 years. What was the age of Midul Medi?
It was, uh, 35 years. As per PM.
Hmm?
As per PM report 35.
As per
As per PM report, 35 years. 35.
and you got the money.
One approximately as per PM.
You are asking for 2 or 1.
4 years. Access to it.
You are only asking for this 4 lakhs for Midul Das. You file your affidavit. Oh, yeah. So what is this order? Mukesh Medi, Mukul Medi, Rimadu? So this is the order for Raktim Medi.
There was policy, I must have been provided to the director, the commission has to pay out a verification exercise. And when only after.
And then also you have paid.
No, no, what is it? That is, that's what I have asked you, that is, what I discussed, that is, not affidavit. person who gives order, can exercise was carried out, and in terms of the exercise, the person concerned was found to be entitled to have the amount was released. That was not a record matter. Because this is only a direction to verify that if found entitled, the person comes within the parameters of that scheme, then you release the money. This is the tenor of this order, which I understand. This is not mandamus per se. Now, he says, man, that person who gives order and the amount has been released. So, let him, we will report that aspect of the matter. In the mission, we will also tell them. No, we cannot see that. But let them know that.
Mr. Borbujari, let the revenue department file an application, not the DC. Revenue department, why I am saying it, let the revenue department clarify what would come within it, so that we can lay down. Yeah, because then what happens, otherwise what is happening is anybody will come and this is what is happening. And then so in some cases, the petitioners will get some, it will be upon the discretion of the authorities concerned. So let it be put by way of an affidavit by the revenue. The instant writ petition has been filed by the petitioner, being aggrieved at the inaction on the part of the respondent authorities in not making payment of the ex gratia of an amount of ₹4 lakhs, which the petitioner claims to be entitled to on the basis of the scheme of the government of India dated 8/4/2015. The claim of the petitioner herein is specific. To the drowning of the husband of the petitioner. Husband. For which the petitioner claims the amount of ₹4 lakhs as per clause 1A of the communication dated 8/4/2015. This court have also duly taken note of the police report enclosed to the writ petition, wherein it is seen that the husband of the petitioner, along with his cousin, went to fishing in a pond from their houses and thereupon was drowned, which led to the death. Mr. R. Borbujari appearing on behalf of the Revenue Department submits that in order to be entitled to the ex gratia compensation, the act has to be an involuntary act and not an act by which the petitioners, the deceased, was himself responsible, which led to his death. So taking into account the specific submission made by Mr. R. Borbujari, this court feels it expedient that the same should be brought on record by way of an affidavit filed by the Revenue Department of the Government of Assam. List the matter again on 13th of December 2023. The affidavit be filed by 4th of December.
Item number 27.
Yes,
My instructions are here, we need 2 weeks to file here.
what is the matter about?
My lord, what is this one? Excuse my lord, the petitioner was a settlement holder of a mining company, recent mining company. The period already expired on 20. Well, our case, my lord, along with the East money, they used to charge 10% of the contract money. East money. And for restoration and reclamation of the area. Where we are extracted. And as per mining plan, since the river with mining, as per mining plan, no restoration and reclamation.
But that is as per the mining rules.
Mining plan is also as per mining rule.
No, that is as per the mining rules you have to pay. I passed a judgment in that regard. Who was there? You, no, Mr. R.R. Gogoi was there. In a similar matter.
Specific subject.
Huh?
Specific subject.
Yes, on this aspect only. There are two aspects which they were charging. One was on this restoration,
Restoration and reclamation.
and there is another one which they were charging. There were two. One I have said that you cannot, the other you can. The restoration and then you can. This is as per the section. You have the mine and mineral rules.
Sorry, my lord. But as per 59, rule 59 of the mining mineral rule, my lord, 2030, they are required.
You may get refund.
My lord, we are for it.
You may
Yeah,
get a
sorry.
refund if it is not required. That is as per the rules.
They are too much, sometimes. But Lordship, there are general objectives under that section. So the fund may be utilized for other objectives.
No, it mentions clearly what is to be, how the amount is to be affected. Have you
Yes.
seen the rules? Where is that rule? Mine and mineral rules? You have it?
In my instructions, Lordship.
No, don't give me your instruction. Give me the mine and mineral rules.
Sorry, my lord.
You are being me on the mine and mineral rules, both of you.
Yes, sorry, my lord.
The council is appearing on behalf of, the council is appearing on behalf of the petitioner as well as the forest departments are not were prepared with the matter for which the matter stands adjourned to be listed after 4 weeks.
Give you.
Item number 28.
Yes,
Settlement of plantation marker that from the forest department issue. And I keep on one divisions of. And regarding settlement of plantation marker. And I keep saying that.
the courts have been issued by the land council for the estate and we expect them
Roadside plantation settlement. And I keep.
Yes, who is appearing for whom?
I am for the forest department.
Ah, are you ready with your records?
Yes, Lordship, we have our records to,
Don't tell me you are not ready with the records. Because last time that was a specific submission that you were not ready with your records.
Lordship,
Or you are still, the forest department is just to come out from the slumber of the autumn recess. Like the earlier matter you have now, you are not prepared. Are you still in the same manner that you are not prepared?
Lordship, we have the records.
Then tell me what is the matter. Well, that was a submission which was made on the last occasion. It is informed to this court that the records have been received by the learned counsel for a forest department yesterday, and he has expressed difficulties in doing the matter today. I hope now that is why this matter has been fixed today.
Lordship, there is an allegation that there is no approval from PCCL since the contract is valued above 1 crore, but our records show that the approval of PCCL was granted. So in order to produce that, we file an additional affidavit.
Tomorrow?
Lordship, 1 week,
No, no, no. You produce the records.
records are here.
Yes, what is your case now? Let's see.
And I think that the 11-101 is that 39 regarding transaction of the water.
Shall not be issued setting aside and quashing the impugned communications dated and through wire written shall not be issued commanding the respondent not to give effect to this. What is this 7-6 and all?
7-6 and also the guidelines was this case that 49.
7-6. This means the tender was open, kept open for 20 days as per the comparative aid valid which have been received in the Iman. 10% less than the estimated rate, therefore the rate which is thus considered valid that the tender may be settled with the 10% less than the estimated. Yes, what is your case, Mr. Bormia?
8% participated.
Who are you?
I am
Risha Infrastructure. Okay, what is this? A tender was issued.
here first.
Show me the tender.
All are technically responsible.
Where?
That is the 8% of the participated person. 6% voted equal to 5% below. And 2%, 1% that voted is equal to 10%. That is also below.
Bid
the-
value below 10%.
and below 10%. That is the below of the estimate point.
Who had quoted below 10%?
10% losses.
Who had quoted below 10%?
7%.
Response number 7.
7.
Okay, then
My tender 5%, and other 6% just 5%, 1% quoted 9%, 99, and 7% quoted 7%. And after opening the compensation losses, it was forwarded before the, you have to forwarded the compensation before the convertible correction, page 53.
where is it?
Page 53.
This is the tender document, 11/1/2021. This is for following packages of works. Roadside plantation, yes, 10% security deposit of the estimated demand. Now, who quoted how much? Yes, this is the Public Works Department. Then,
Then losses. Page 55.
page
55.
55. Yes.
55. That is letter dated 25/2020.
Yes,
Column 4 losses. We lost that the finances we obtained from the net on interest control. And that is not going to replace from the comparative statement, the tender under serial number 12357 apart the EPL bill. As rupees also that is 5% below from the estimated cost. The tender under bill for full apart 10% below. But the standard 0% apart 9% and then below from the estimated cost. As per the notice number also, that detated by the teacher and form. Some by number also, the copy of the letter is enclosed on the respective, the tender syllabus, food and fees cannot be accepted, whereas the other fees and the quoted equal law. The ultimately rejected
the tender serial number 4 and 6 cannot be accepted, whereas the other 6 tender quoted equal offer.
equal.
Okay, now it was given to whom?
Even to 7.
Number F, the bidder researchers submitted all the required documents along with the financial capability and liquid assets. Moreover, the tender having a specified date. Now thereafter,
It was recommended in favor of the petitioner, but thereafter by letter dated notice, page 57.
hmm,
In this letter, letter 17 to 21.
estimated
That was issued
rate.
by the commission chief conservator of forest, the principal chief conservator of forest, and head of forest.
Okay, then,
Then lordship, where as lordship is the content of the fine was on last part given as per the comparative statement. 8 very trees have been received in the camp. Messrs. Mechanism, Mildas, and Timar, their lowest bidder. The lowest bid is 10% less than the estimate. Therefore, the copy is that consider we that the tender let it settle with Messrs. Mechanism Mildas for the appropriate loss. So, he proposed to give to him, that is respondent number 7 without giving any details for
then,
losses on the basis of this letter, page 60 losses, approval given to provide the safeguard to the soul of them. And according to the basis of this letter losses, what for the has been issued. That
okay, then,
I am challenging this order, it has been rejected.
so your basic case is on the basis of this communication of the PWD.
No, not the
Yes,
forest department also.
understood, but that is this PWD thing,
Yeah,
na?
this one, but
This
acceptance
at
of
page 46,
page 49.
49 or 46.
46 is the PW department, 49 is the forest.
Let us read 46
Yes,
first.
46.
Yes. Observe that unreasonably lower rates quoted by some of the civil works contractor vis-a-vis the appropriate cost has been adversely affecting the quality of works.
It has been observed that unreasonably lower rates quoted by some of the civil work contractors, that is the absolute superior cost that is adversely affecting the quality of work, as well as timely completion of the work. And on the other hand, unreasonable higher rates quoted by some of the civil work contractors whose undue pressure on the trade, etc. And therefore, in the interest of public service, the governor of Assam is pleased to notify the following principle for short of all civil work contracts under the Assam PWD Act. The regulation of the quoted price up to 5% positive permitted over the approved distributed cost of civil work and the regulation of the quoted price up to 10% positive negative may be allowed for peculiar situation and in special circumstances. And the reason for allowing this sort shall be placed on the record by the officer responsible for accepting the tender. Tender is beyond this release shall not be accepted above the as part of the platform. The privilege may exceed and such delay until further.
Now let us read 49. Let us read 49.
Yes, say what it is. Page 50 is the respect of
Yes.
the limit of acceptance of quoted. The preference of objects is such about this information. Some contractors are quoting unreasonably worded as compared to limited cost, which may impair the quality of the work, and on the other hand, some contractors quote higher rates, which may put undue pressure in government funds. In this regard, to avoid unreasonably higher and unreasonably worded government.
So you are on number 2 and number 3.
Number 2 and 3. Number 2. Number 1 and 2. Is
1 is not relevant.
5%.
5% is not relevant. Let us come to 2 and 3. Yes.
The full variation of quoted price up to rate up to 10% positive or negative over the absolute fiscal cost may be allowed for peculiar situation and in special circumstances. The reasons for allowing up to 10% positive or negative shall be placed on record by the officer responsible for accepting the capital. That mechanism. The reasons for allowing. Tenders beyond 10% positive or negative over actually the cost shall not be. So here is the incentive 5%.
So below 10%,
Yes.
beyond 10% positive and negative cannot be accepted.
But here is the below 10%.
Yes. And here
10%.
in this particular page 55, it has been said that the serial number 4 offered 10% below.
Yes.
That is your case. Yes, what is it? That is his case.
Yes, no.
Pilots, it's at 10,
at par with ten, it's not below ten. And apart from that, we have filed affidavit. But there's, I know that gone to the page 49 and 15. They provide for special circumstances. In this case, my lord,
No, no, 10%, okay.
10%.
The 10%, it is okay.
Yes.
You can record reasons and give.
Yes.
But below 10%, you
I
cannot.
understand, madam. It's not, it's at par at 10, it's not below.
No, because page 53, kindly see page, not 50, page 55. Serial number 4.
Offered 9.99%,
No, 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 no. We are not, we are at serial number 4.
10%, madam. It's 10. It doesn't go
Offered 10% below.
10%, that's, it is 10, my lords.
Now 10 is okay.
It's 10.
Then you have to record reasons.
Yes, sir.
Show me that. That's all. What else is
So, my
required?
lord, what the letter he's harping on is the of the conservator. Whereas, my lords, this value of the tender is beyond 1 crore, for which, my lord, the authority, empowered authority is the PCCA. So, records.
No, 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 no. We are not on all these things. This 25 to 2021 otherwise has no value. I'm not saying that. But the fact out there at serial number 4 is clear to one aspect that as regards the tenderer at serial number 4, who is the respondent number 7, his quoted rate was 10% below. And if you go to that particular document of the Forest Department, it has 3 conditions. First, if it is 5% below or above, whatever may be, then you ignore it. If it is 10%, up to 10%, for special reasons you can. But beyond 10%, you cannot. Now he is harping on, his argument is, on the basis of this 25 to 2021, is to the effect that here the conservator of forest categorically mentions that the person at serial number 4, who is the respondent number 7, score was below 10%. That is his case. Now tell me whether it is below 10% or up 10%.
It's 10.
Show me.
It's 10, my lords. It's 10, and we have filed an affidavit. But when the person gave my lord, it's 10, the respondent.
That is why we asked for the records.
Asked, records are there.
Show me.
He was asked to, my lord, justify his offer and that price.
No, no, that is okay. First, let me see as to whether it is 10%. Then the entire edifice of this case goes. No?
So my lord has to do some calculations.
I won't. You are there to help me out.
Additional flex are the later part of the report. If you see, madam, this is a
Value of the contract is how much? It's 2 crores 56 lakhs 64,070. Okay,
it's my lord,
2 crores
2
56.
crores 30 lakh, 2 crores.
No, 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 no. Annexure 8 is the tender document. Page 39. We are concerned with Annexure 8, page 39.
But there are various packages. So you're concerned about package 2.
Where is the package 2? There is only one tender. Says about package 1. Are we concerned with package 1 or package 2?
Package 2.
Package
So
2.
where is the package 2?
The cost and amount is directly mentioned, but in the tender process, here in the quoted one, the applicant all are documents, these 2.
No, no, Annexure A
A,
is for package 1 or package 2.
it is a package, but only type package 1.
Is
All
it?
other documents plus it package 2, including that applicant.
Okay, what is the value of package 2?
2 crores 56 lakhs 64,070.
2 crores 56 lakhs 64,070.
Yes.
What will be below 10%?
Below 10% of the 2 crores 56 lakhs 64,070. 10% of the 10%. 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 10 2,30,97,668. That's not like that. The company statement was in the beginning.
The total figure is 2 crore 30 lakhs 97,663.
On the statement.
So it can't be below 2 crores 30 lakhs 97,663.
That's my responding on at the par, my lord.
No. It can't be below this.
Below it, so it's par.
Now, how much did he quote?
He put it at exactly 2 crore 30 lakhs 97,000.
And
97,663.
so it is 10%.
It's 10. It's a par.
So then we are to, it is not below 10%. So the next question is whether they have reasons recorded.
They are the 5 brothers, they are very tender. Yeah, 5%.
No, it's okay. Where reasons recorded. Who is the respondent number 6? Okay. What does he say? What is the reasons recorded for giving him?
AFO just recorded, my lord, he didn't record it, we sent it to the higher office. Because it was beyond his authority to accept tender beyond 1 crore. It was sent to the PCCM. So in between, my lord, the conservator state that we cannot, because it's 10% below, but I have indicated that it is at par. So additional PCCM, social forestry, my lord, he made a note, he made an observation that it will save public money and it is at 10%, so it should be awarded to 10%. It is endorsed by the PCC.
Where is that?
Well, that's records,
Records is there. Which one?
records. Sir.
Where is the proposal of APP?
It's flag, my lord, I have to pinpoint it. The flags are there.
Which flag? Which means the tender was kept open for 20 days. For the open list 6 bid value which has been and has emerged with the lowest bidder, the lowest bid is 10% less than the estimate. Therefore, this office is to continue to use the mapping secondary. Are you saying about the 7/6/2021?
Perhaps 7/6.
You are just giving it because it is the lowest.
To save public money, my lord, that's.
Where is the money? There is nothing mentioned out there in 7/6.
The contractor, my lord, towards response 7,
he was asked to offer, he was asked to show cause, how he can proceed with, well, he gave an, explanation which is accepted.
Where is it recorded? There seems to be no communications to that effect. There seems to be no communications to that effect.
After that, he was, when he was, person was given the allotment of, he was asked to proceed, madam. The DFO, madam, issued a notice to the.
Where is it?
In the first seven. It is replied, madam, our affidavit.
So where did it should have been a part of the record? If that was made the basis. And have it just for the sake of it. The records are not there.
Affidavit, madam, where it is addressed and,
No, no, no. Mr. Gogoi, whatever may be, if you are making a decision, shouldn't that be a part of the decision-making process?
definitely.
Is it there? Is it, it should have been recorded in the note sheet. Because there is one place somebody has written, has the tender opening recommending committee given specific reasons for proposing L1 had quoted works to be done immediately and the loss of delays already. Something to that effect. Paramesh Malla Bujagurwa, who is he?
That's different, ma'am. That's a different package from Nalbari. This file contains all the doors of my heavy.
Where is it as regards yours? There's nothing mentioned. When was the tender opened?
Tender was opened for the technical, we opened on 6/2/2021.
6/2.
Technical.
And then
Financial, we was opened on 17/2/2021.
how much?
17/2.
Yes, show me in the office, your office notes where they have taken the decision pursuant to 18/2 and 19/2. What is the decision after 18/2 and 19?
So the, this first minor witness evaluation financial is open. Then the DFO forwards matters, he is proposing to the conservator. Conservator writes, whereas DFO says, awarding is for number 7. Conservator takes a different view, sends to the higher ups. Higher ups again, they take a different.
Where's the decision?
This is a little bit that it's 10% money should be awarded because it's below 10%.
Why? Can that be the reason? If we let us look into this particular aspect, when it says variation of the quoted price up to 10% over the estimated may be allowed for peculiar situations and in special circumstances. What do you mean? Give the meaning. Can being the lowest tenderer and would save the money would be the only reason out there? Then why not do it below 10% also? That can't be the reason. There has to be some reasons recorded. The reasons for allowing 10% shall be placed on record by the officer responsible for accepting. Where's the officer's records?
With another set of records and we're going through that.
So we only want one thing, because your review meeting, which you have enclosed to the affidavit, does not reflect the reasons why. Then anybody can quote below 10% also. If that is the basic reason that it is below, that it saves the government money. Can that be the reason why? It has to be in peculiar and special circumstances.
Justify how he's offering such a low rate.
Absolutely. But no, he may give any justification.
He gave.
But have you taken into consideration those justifications and come to a decision? That's all. And not only that, you have to record your reasons
I understand.
that it is feasible. Even at 10 below 10%, up to 10%, it is feasible. There has to be peculiar and special circumstances.
I have nothing more to submit. What you asked.
You don't have to, then I record it, you have nothing to submit.
This record I have to.
I'll record it that you have nothing to submit. Allow the repetition. No, Mr. Gugoi. You are making a submission. You are a responsible officer of the court. You can't make a submission that I have nothing more to submit.
The records.
I'll record it. If you have nothing more to submit, I'll record it that you have nothing more to submit.
This is very heavy. This is very huge.
No,
Yes,
are you still in slumber after the autumn recess? Because on the last occasion, you appear very much and you said that you need some time to look into the records. A month has gone by. And Mr. Muzumdar, you are appearing for? And the private respondent is looking into the records? Is this the state of affairs?
No. This is not all rules.
No.
These
Are you allowing the private respondent to look into the records?
This is just a matter analysis.
This is the state of affairs of the forest department.
Only as.
See the pollution?
Nothing.
My goodness.
This is not a paper I was just trying to find out from the Mushi part.
Who are you?
After
No, you are the respondent, 7.
I think this one should be so.
Now, Mr. Gugoi, are you assessing these records to the petitioner?
He can,
Show it to him.
yeah, I guess. Let's be fair.
You are not assessing the records to him. Why are you assessing the records to respondent 7?
Everybody, if they want, well, they can see, because this is a record which I placed now. This records cannot tinker with. However, this records, I'm just trying to find the note sheet.
That is,
If he can help me out, then I can give you.
no, he cannot find something which is not there. And you have taken time only for going through the records for a month.
kind of like big content out, we like other option.
Why? To further delay it.
No.
Then,
That is stuff in picture.
No. that was never what you wanted to say on the last occasion. You said on the last occasion that you are going to look into the records and you have received the voluminous records and you have not been able to look into it. That's all.
I recall.
Then,
I remember. These matters I have gone through. These matters, I'm just trying to help them. If there's anything at all.
Now, this court, by an order dated 24/8/2023, at the request of the learned counsel, Mr. D. Gogoi, for the Forest Department, had granted time for perusal of the records so that this court could be assisted properly. However, when the matter is being taken up today, the learned standing counsel for the Forest Department seems to be still unaware about the contents of the records. Taking into account the above, let this matter be listed tomorrow at 2 p.m. before the court. A final opportunity is given to Mr. D. Gogoi, the standing counsel for the Forest Department, to assist this court as regards the records. And you show it to him also. You want to have a look at the records. Yes, Mr. Das. Yes, what is the stand, madam? Last occasion, I've asked you to approach the deputy commissioner. What has happened? It has been mentioned the petitioner has been allotted a plot of land measuring 2 bighas, 2 kathas covered by dark number Iman and Iman of village Iman. By the allotment proposal dated lists the matter again on so and so. Liberty is given to the to approach the reserve for the purpose of completion of the form. Yes, what happened? What? No. Have you, Mr. Das, have you approached the authorities pursuant to the order passed by this court on 4/8? Then, no, Mr. Das, you should come. Bring your basic case is that you are entitled to, you should be given an allotment. They say that they have given you an allotment. Only thing is that now you have not received the patta. I gave you the liberty in the month of August. Approach the deputy commissioner so that he does it pursuant to this order. If you had done it, then the thing would have come to an end. But it seems that you are not responding, interested. No. Not only the handing over possession, you also require the patta in your name. Don't you think so? Then why haven't you approached the authorities concerned? Well, have you approached? They say that they have already made the allotment in your name. Pursuant to the allotment, you know what are the things which are required to be done. Then, the land which have been allotted to. Dag number 75 and 114 is such a small dag. How much land has been allotted to you? Put it on affidavit. Mr. UK Das, the learned counsel appearing on behalf of the petitioner, is given the liberty to approach, is given the liberty to file an additional affidavit as regards the submissions made to list the matter after 4 weeks. I can't help you. If you are not helping this court, I am not going to help you. Sorry. This matter would never come to an end. I was trying to help you, you are not, you are not interested with the matter. I can't help you. Now you are ready to accept. Why haven't you approached? I gave it in the month of August. August was September, was October. On 5th of October, you approached. What is wrong with you? Then you should have been more careful. I don't understand. Does the petitioner counsel or the petitioner wants a finality to the litigation? Your basic idea is that you get a patta. Your basic idea is to get the possession of the land. You should be happy with that. When a liberty has been given to you, you have not approached. Once you have approached, they don't do, then I can pass appropriate direction. I can't. Can't help you. Do whatever you like. Yes. Yes, Mr. Goyal. Oh, that matter. What case you have? You wanted to withdraw?
No, my lord.
Okay, tell me.
Because compared to what my lord did say.
Yeah.
I am before your lordship for the interpretation of my lord provision
Interpretation of?
subsection 4 of the Railway Trade Tribunal Act. If we read this preamble and the different provisions of the Act, my lord, the conclusion of what my lord, in my humble submission would be my lord, that I am not against the provision given under the Act. What I am committing, my lord, yes, a single member can take up the matter, but if that matter is taken up, it should be my lord division matter on. That part, since it is not there, so if you read my lord my lord rule 4, it says my lord regarding my lord framing of question of facts and law, preamble and different provisions of the Act as well as the rule, your lordship. And in view of the judgment rendered by Honorable Apex Court in Roger Matthew, your lordship.
No, Roger Matthew was on a different aspect. This is a case where it categorically says this Act categorically says about in what manner it has to be done.
Subsection 4.
I go down.
My lord, if we read in isolation, my lord, that particular provision has been quoted in the read petition also. But if we read in isolation, my lord, then it is all right, my lord. But if we read together with preamble and all, my lord, you will also find that
Preamble or all.
my lord, I have given my lord Act, your lord.
Yes, I've got it. Yes.
And my lord may kindly come to Railway Claims Tribunal Act and
Yes. The claims tribunal shall consist of a chairman, vice chairman, number of bench shall consist of one judicial member and one technical member. Anything contained in the chairman may, in addition to discharging the functions of a judicial member or a technical member to which he is appointed, discharge the functions of
a
the
bench shall consist of one judicial member and one technical.
Then it says, notwithstanding anything contained in one, the chairman may not say anything contained in one, it shall be completed on the or any other member authorized by the chairman in this behalf to function as a bench consists of a single member and exercise the jurisdiction power authority of the claims tribunal in respect to such class of cases or pertaining to such classes of cases that the chairman may by general or special orders. So this is the 4 is the power.
This is the special provision. It can be, my lord, assigned in the special circumstances and this is under subsection 4. What I am submitting before your lordship.
So why you are saying about special circumstances?
Because it says, my lord, the power authority of claims tribunal in respect of such classes of cases.
So there is a difference. Such classes of cases is different and for special circumstances is different.
Or such matters pertaining to such classes of cases.
Absolutely. So some particular matter may be assigned to some member. The special circumstances is a difference. Yes.
And now, my lord, they can come to determination of. The lordship may kindly come to. Rules.
Yes.
Rule 21. Framing and determination of issue.
Hmm.
After considering the reply, the tribunal shall ascertain upon what material propositions of fact or of law the parties are at variance, and such and shall thereupon proceed to frame and record the issues upon which the right decision of the case appears to it to depend. In recording the issues, the tribunal shall distinguish between those issues which in its opinion concern points of fact and those which concern points of law. After framing the issue, the tribunal shall proceed to record evidence thereon, which each party may desire to produce. So what I am submitting before your lordship, madam, tribunal, this is the, in fact, rule 41 is mandatory that a decision is there, madam, of this on the report. And tribunal is required to, my lord, frame issues on question of facts and question of law. And the composition of chairman is, my lord, a bench consists of judicial as well as my lord, technical men. So far as my lord, question of facts, I can well understand that. But so far as question of law is concerned, my lord, in my humble submission, my lord, judicial member is the person, my lord, who can, my lord, decide the issue on so far as question of law. That's why, my lord, for the special classes of cases, my lord, learned chairman can assign, my lord, single member, but that single member in my humble submission, my lord, it should be, my lord, judicial member, not technical. Because judicial member can decide so far as question of facts also. But question of law, the person who is conversant and who has experience in the field of law, my lord, he can better adjudicate the matter rather than the person who is technically sound, who works in railway.
No, you see the proviso to section 4(4).
Provided that if at any stage of hearing of any such case or matter, it refers to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of 2 members. The case or matter may be transferred to the chairman as the case may refer to him or transfer to such bench as the chairman may keep it. This question, my lord, is my humble submission. Given before honorable effects, it was in respect of administrative matter. Honorable effects for head, my lord, if the prayer is being made before the bench, who is sitting singly, refer the matter to larger bench. The prayer, my lord, should be, my lord, accepted. In the present case, my lord, prayer was made before the bench to refer the matter to larger bench or a bench consisting judicial member of. So that was rejected despite the direction given by, because this is second round of litigation. Despite the direction given by this honorable court, and then for other petitioner, if the first type of prayer is made, it should be, my lord, in view of the effects for decision, it should be accepted. That earlier order which you will find at page 47, my lord.
Yes.
Operative part page 49. It was this requisition was filed by some other company, but the direction was not. I have given due page 49. May I read? I have given due consideration to the submission made by learned counsel. Here in this matter, the application is agreed that.
Then what happened? Thereafter?
So this direction was given again. Then I have filed, my lord, application before learned tribunal, your lordship.
Where is it?
Page 56, my lord.
50?
56, my lord, annex of 4. Petitioner before your lordship, he has filed, my lord.
Related parties,
Then
it was rejected, page 58, madam.
what is this order? Passed on 15/3/2021 in WPC number 5712.
That order, madam, page
Ah.
47 now. Part by this one.
What is wrong with this portion of the order, paragraph 6 and 7 of the order of the RCT? Paragraph 6 and 7, page 59 and page 60.
Honorable Chairman, as we have, is also part and executive of the part. All those are. But in the thing that warranted measure, condition of market, but the rule mentioned in that order that the vacancy occurring cannot render the. Of religion schools and points of facts. Very wrong.
But
So far as rarely with points of law.
what is the point of law? So what is wrong with this order?
That's why the order by which my learned technical member was appointed, page 46.
Yes.
Last paragraph, on the basis of the judgment, you also have talking. On the basis of the judgment of double bench comprising of then chairman, honorable taken on the above section. So my lord, direction was.
As a single member on the basis of the judgment.
Single member was directed to decide the matter on the basis of the already given decision given by my division bench of the 11th. In my humble submission, that direction cannot be given to the learned member technical to decide the matter in a particular manner. At the best, learned chairman can say that yes, you can decide the issue relating to terminal charges. But learned chairman cannot say, my lord, you decide this issue on the basis of division bench decision. And that is amount, it will amount to interference in the judicial proceeding. Number one. Number two, my lord, learned tribunal says, member technical, question of law is not involved. Whereas this honorable court, in the earlier round of litigation, directed that you submit.
What did that order say? There is already an order passed in respect to terminal charges by the division by 2-member bench. So they say that 2-member bench have already decided this point. All these points be decided now by the single judge out there.
On the basis of division bench.
Absolutely, on the point of law, which have already been decided. That is only to be applied.
Well, each case rests on its own facts.
Huh?
Each case rests on its own facts. Whether the decision rendered by earlier division bench is, whether it was applicable or not, that is also.
No. Here
The
it
moment
says,
that it-
decide the matter pertaining to terminal charges of RCT Guwahati bench as a single member. Only on the terminal charges which have already been decided, how it is to be decided.
Only terminal charge issue is now. What is terminal charge? The interpretation of particular circular law.
No, that is, whether the terminal charge has already been decided by the division bench
Of the tribunal against.
of the
that-
tribunal.
Against that, and this was before this.
Forget about the MFA. MFA, we are not concerned with that.
Why I am submitting.
I'm only saying, just for example,
Come on.
let the Supreme Court today, tomorrow decide a particular issue. Thus, every time the matter needs to be gone to the Supreme Court for that issue. That can be very well decided by us.
In that case.
Then are you going to say, no. Every time the facts are different, that is why the Supreme Court is going to every time decide. No, that is not the.
Law, I agree with you a lot.
No, the applicability as regards, this is the terminal charge, whether it is to be applicable in this manner or that manner, that has already been decided by the division bench. Now the division bench say, the review of that, they say, let there be a single judge out there who will dispose of these matters in line with what has been decided by the division bench. What is wrong with that?
Against that, appeal was preferred because this honorable court by under section 43 of the Labour Code. This honorable court has taken the different view that this honorable court has upheld the judgment of the matter, but the basis on which that judgment was upheld, it was that the facility, because as the lordship knows, my lord, charges, it is like one compensatory in nature, the law. If you are taking charges, then you have to compensate by way of giving facility. So what this honorable court, that judgment I will say, my lord, that those facilities are there on that basis.
Forget about this court. If that matter has gone to the Supreme Court, once the Supreme Court also decides. No, I'm saying, let us take an example. The matter after the division bench or two members have already decided in the RCT, the matter has come before this court. From here, it was carried to the Supreme Court. The Supreme Court decides the point. Now, after that, what is to be done is to apply that same principle, and that is what the single judge was applying. So what is wrong?
But in my humble submission, my lord, in another, because number of.
If a new fact arises, a new question of law arises, beyond what has been decided, then obviously it may be a case.
For that, my lord, if I will place before what is terminal charge.
No. First, you have to show me what is the decision of the two-member bench.
They have just taken that, because so many division benches.
No. Here they have mentioned that there is a decision. Yes, Mr. Sharma,
The number and all.
these
That I will say.
two-member bench have decided the point. Rightly or wrongly, there has been a decision. What is being done is they are appointing a single judge who will deal with only on the basis of the same principles which have been laid. Any deviation from that principle, if it goes out of that principle, then obviously the technical member may not have the expertise to do that. But following the decision, applying the decision to the facts would not entitle, it would not require any further decision to be made.
Can it be taken up tomorrow? or not?
Why?
No, I
Tomorrow?
will bring all the decision. It is up to you.
Isn't that, Mr. Sharma?
I will have division bench judgment was upheld by High Court member, that is MFA handed up to Congress.
But I also.
Whatever may be, whoever argues it's a different thing. But the fact is, tomorrow a Supreme Court decides a particular issue, that this terminal charge is to be taken in this manner. If a fact-finding inquiry applies the same on the basis of the principles laid down by the Supreme Court, what is wrong with
May
that?
I submit in different way, my lord, if your lordship permits me?
If it is a case where the fact-finding inquiry goes or bypasses the Supreme Court judge, and decides a point of law which is divorced to what has been decided by the Supreme Court, then obviously you may have a case. But otherwise you don't.
May I submit my? The
Yes.
levy of terminal charge, whether it can be levied or not. Division bench, particular bench has said, yes, it is permission. My lord, another member may differ with the observation, it may refer to the matter to larger bench also, this is the practice of also. But that scope, because of the notification issued. by-
No, tell me one thing. Can a judgment of the division bench of this court be referred to a larger bench by a single judge?
No. Before
Matter
division
is-
bench,
No, it can go to a division bench, it's a different thing. But this single bench cannot.
but single
same
bench
thing.
will refer the matter to larger bench.
No,
The
no,
division
for
bench-
that it is not required. You can very well carry out against that order before this court. You have an appeal, you have a scope and appeal.
I will try to apply the.
Tomorrow, 2 o'clock. This is the. Because 4 the power is there.
One of the mother has 4 acres of land, my lord. And one of the petition number 2 as a daughter she purchased from her mother by executing 2 separate sale deeds. My lord, by executing 2 separate sale deeds and then 4 acres of land purchased by the petition number 2. In the meantime, my lord, the.
Who is the petitioner number 2, private respondent number 2?
Petition number 1. In the meantime, my lord, the private respondent number 4, who is the son of petitioner number 1 and the brother of petitioner number 2. It is the same family member, my lord. He executed a tax sale deed,
Who?
respondent number 4.
Who is respondent number 4?
Sale deed, my lord. He told that he has purchased a plot of land measuring 1 meter from Tata, my lord, from the petitioner number 1. This is not correct. And my lord, a dispute was arising, my lord. He filed a petition before the son of court, respondent number 4. And this son of court was we could direct the responding authorities to look into the matter and take an answer like that. And I had an order of the court. My lord, in the meantime, my lord, the respondent number 4 was trying to mutate the entire land, my lord, in his name.
The land which he has purchased.
Which he has purchased by executing a failed technique.
That is another aspect. We'll look into it there.
By suppressing the fact that the petition number 2 has purchased the land from petition number 1, that was suppression. So we came to know about the matter, my lord, and we filed a petition before the son of court, this petition, my lord. And notice was issued, we take step, notice sent to the respondent number 4. My lord, without
Well,
responding the notice.
In the first petition, what have you challenged?
My lord, I challenge that we pray for a direction, my lord, to the responding authorities to mutate the land, my lord, in the name of petition number 2. That was our prayer. In 5-8,
Not to mutate in the name of respondent number 4 in respect of so and so, and to allow the petitioner number 2 occupy the entire land who had purchased for the petitioner and not to disturb the possession.
that was, in the meantime, my lord, the Latmondor passed an order, my lord, which I have challenged here, my lord, in the second petition. Latmondor passed an order saying that the land is mutated in the name of private respondent number 4. But Latmondor cannot pass such order, my lord, circle officer can pass the order, my lord, the last of the petition, last page I have an order. Now, another thing is that, my lord, the date of sale deed of the tax sale deed is.
Who is appearing for respondent number 4?
My lord, another thing, my lord,
Hmm.
My lord, his tax sale deed may kindly, my lord, that is page number 39.
Where is the Latmandol's report?
Page number. Yes, Lord, may kindly see page number 39, the date, my lord, I have given P712. This was the date of the sale deed executed by the respondent number 4. Now, for a moment, Lord, may kindly come to page number. Can we come to page number 46, 46.
40?
43. 46, yes. relevant portion 47. You know.
Hmm.
Fourth line, my lord. Salary dated 7/3, different salary, date is different, my lord. So now again, my lord, confusion, my lord, the different date. So he did not stated the actual fact in the earlier description.
That is immaterial. Now the question is,
But now, last page, 74, there is in there. 74 particular, last portion, my lord, signature of Black Mondo, but not the signature of the circle officer. Black Mondo cannot pass such order.
where?
My lord, page number 74.
Hmm. These are not orders. Where? Which portion you are reading? 74, which portion?
Page number 74, right hand side down below, my lord.
মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয় ইমান নম্বৰ গোচৰৰ No, this is only a remark. The order has to be passed by the officers.
In the earlier remark, my lord, in the earlier remark, circle officer signature is there. So, my lord, our prayer is, my lord, permission is there, my lord. The petitioner number 2 is the actual and legal owner of the plot of land.
Okay, now first and foremost, when was the petitioner number 1 is the actual owner of the land? What is the name of the petitioner number 1? Sofura Khatun. Okay. Now Sofura Khatun sold the land to the petitioner number 2. When?
First, 25/11/2010. And for 2 years,
25/11/2010.
there's number 15.
15.
Yes.
This one.
This is for
Okay.
2 years. And secondly, my lord, another.
So
2
this
years-
is a plot of land of 2 bighas have been sold.
So, and
Okay.
another 2 years.
And when was the purchase made by the petitioner number 2? Respond number 4.
My lord, that is case number 39. P712,
T7/2012.
case 39.
Why you have not given the entire translated copy of the Huh?
I have given the particular in the next.
so what? Vernacular giving, how does it make a sense?
Yes.
No, if this is a false sale deed, you are saying the second one is a fake sale deed.
Not second one, my lord. I have NS3 said it, my lord. Who is for the petitioner number 1, 2. She purchased the land, 2 years earlier and thereafter 2 years. 4 years.
When did she purchase?
He purchased for the first time, my lord, 25/11/2010.
2010. 2 bighas.
And another 2 years, my lord, 14/8/2016.
14/8.
2016, 14/3, my lord, 14/3/2016.
16.
Yes.
How much?
Yes, 2 years.
2 bighas.
Today land is 4 years.
Total is 4 bighas.
4 years.
Now, petitioner, this is by petition number 2.
And my lord, the next shall be executed by the respondent number 4, is number 39.
Is for how much land?
Then
1 bigha, 2 katha, 10 letters.
Right.
Okay. This is, the mutation is done only in respect to this land
land.
in favor of the petitioner number 4, respond number 4. So you want the cancellation of the mutation.
Cancellation of the mutation.
Now tell me, have you approached the ADC? Have you approached the ADC?
My lord, agency and cases are closed pending, my lord, process. Case number 64 onwards, my lord, and the notices, my lord. And regarding this plot of land, the case is pending.
Then why have you approached this court? There's a suit also pending, suit for right title and interest.
Pending or not,
Well, it is there. You are saying at page 67.
but it's not, the case was pending at that point of time.
Then
But thereafter, I understand that he has decided to like that manner, manage the last model manner, to mutate the whole, the land, land is become in his name, and accordingly it has been mutated. So I have tenancy.
no, why have you challenged here? No, tell me, Mr. Counsel, is this court in a position to decide whether the sale deed is fake or not?
Sale deed executed by the son of court.
Yes. Is it fake or not? Can this court decide? Tell me.
That is my lord, that the date is wrong, my lord. And my lord,
No, date is wrong. The sale deed, forget about what has been recorded in the order. You see the sale deed, which is there, page 39. The date, this is the certified copy of the sale deed. We'll go as per this.
but by showing this, sale deed, my lord, the responsible for filing retreat on this on our. Where,
Whatever may be, the court may have wrongly written it. So does it give you a case out there? Your suit is pending out there. One is the suit is pending. The second is you have to move the deputy commissioner against this order. You are aggrieved by that. Why should this court at all interfere under 226? Because this court cannot decide whether the deed is fake or not. This court cannot decide because there is already a suit pending as regards right title and interest, which has been filed by respondent number 4, isn't it? So you are to contest out there. Then you withdraw these matters and say and submit to the effect that the withdrawal shall not prejudice you in the suit which has been filed out there. And the outcome of the suit pending therein shall, because if the sale deed is fake, isn't it required for you to challenge it? Have you challenged it? Then
another of the, I say, my lord, that I may be allowed to approve the appropriate forum, my lord, by challenging this mutation model.
you challenge it. All these things you can do it very well. But the only thing is, unless you challenge the sale deed, you're in deep trouble. Why you are saying, why I am saying this? Kindly see this. These are suits of 2017. You are saying it to be a repetition of 2017. You are saying that that sale deed is fake. So your limitation as per Article 123 of the Limitation Act starts from the date of your knowledge. 3 years. Where will you go? And this court cannot decide as to the authenticity of the sale deed.
I may be allowed to do that.
Because what you are submitting as regards the Latmandal is also wrong. You see what happened? These remarks, this is not done there. It is in the remarks column. Remarks column, these are being inserted by these officials, not the circle officer. On the basis of orders being passed. The learned counsel appearing on behalf of the petitioner submits that the sale deed on the basis of which land measuring 1 bigha 2 katha 10 lecha covered by dag number 53 included in patta number 28 of Jamalpur village of Posim Dalgaon, Moja under PS and sub-register Dalgaon in the district of Bongaigaon, Dorong. Which have been put to challenge in the instant writ petition, is the outcome of a fake sale deed purportedly executed by the petitioner number 1 in favor of the respondent number 4. He submits that as the question relating to the fraud committed in the execution of the deed of sale bearing deed number 101 dated 3/7/2012 cannot be adjudicated in the present proceedings. He may be permitted to withdraw both the writ petitions with a liberty to avail appropriate remedies before the competent civil court as well as also before the authorities concerned. He further submits that the withdrawal of the instant writ petition should not prejudice the petitioners in such proceedings which the petitioner may institute assailing the purported deed of sale dated bearing deed number 101 dated 3/7/2012 as well as the mutation done in favor of the respondent number 4. Upon hearing the learned counsels for the parties, this court is of the opinion. This court permits the petitioner to withdraw the both the writ petitions and grants liberty to the petitioner to approach the appropriate civil court as well as also the competent civil court as well as the appropriate revenue authorities. It is further made clear that the withdrawal of the instant writ petitions, both the writ petitions, shall not prejudice the petitioner in respect to such challenge to the purported deed of sale bearing deed number 101 dated 3/7/2012 as well as the mutation done in favor of the respondent number 4. If otherwise permissible under law. Article
Responding agency will finally authenticated a short time ago. I will let some friends to find a reply.
that was given long time back. You filed today. Okay. The respondent APDCL had filed an affidavit in opposition today. The learned counsel appearing on behalf of the petitioner seeks for an accommodation of 4 weeks for filing a reply. List the matter after 4 weeks.
Article 34.
Yes. Ex gratia of 5 lakhs. Why? Forget about the affidavit. You tell me why. What is the basis on which you are entitled to?
that cover your lordship. That when the money was killed by that state,
When did when did the incident happen? When did the incident happen?
1989, your lordship.
So 1989, how are you entitled to 15/11/2014?
Hello, there are an aspect of the your lordship.
No. No, this extremist attack is 3 lakhs. Isn't it?
Thereafter, it was enhanced, your lordship.
Where?
Notification, your lordship will find. I have enhanced your lordship. Notification, your lordship.
By noticing it is highlighted as part of notification of the, 15/11/14.
But 15/11 only, 15/11/2014,
And next, sir,
But the incident is of 1990, prior to 2014.
that is what 15/11/2014 is only applicable in respect of incidents which may occur in state or on or after the issuance of the notification.
And next, sir, see your lordship, page 20.
Page
20.
20. That is what I am saying. Kindly see the third paragraph of the line. The revised rate shall be applicable in respect of incidents which may occur in the state as on or after the date of issuance of the notification.
November, your lordship, 2014. But your lordship will find a notification 6 December 2014.
Where? Got it.
Page 20. There it is, in supersession of all earlier orders. And in pursuant of clause 3, article 7 of Constitution of India, have all powers and authority. We have the governor to direct that the following further amendment shall be made, usual transfer, delegation, and initial transfer. As number 1 is to sanction of appreciate grant to the next of kin of person killed and who is the person killed, age is 18 years or 7. Number 1. Rupees 5 lakhs. Earlier, all notification you will superseded by this notification. That is why the petitioner is entitled to receive 5 lakhs. That is why I am elected to file the affidavit in opposition. I shall clear the affidavit.
This is the rate which has been made. This does not amend this notification.
Let it file the affidavit in opposition. I shall clear the matter. And then they are not file affidavit.
This is the power of delegation.
That notification, the superseded of earlier power of notification. That is when the petitioner is there. So let them file it.
No, this is there is another one. Women political, which gives this 3 lakhs. Where they have received? Then they want more.
Fine.
Why?
5 lakhs is as per notification you will.
No.
This notification.
No, nothing with.
6 December 2014 you will.
No.
So that is why let them to file affidavit. I shall file reply.
An affidavit has been filed in the other matter.
Other matter file, you will see how they are filing in they have put it the wrong number, it's the wrong repetition number. My repetition is 647. But they have filed the affidavit in 64720. So regarding that, my reply is ready, but due to the wrong number, your lordship, I cannot file. My affidavit reply is ready. In this report. But they have put it the wrong number. My repetition number is 647. Let's say you file reply, you know, by correcting their number, you know, they
Where?
have put the wrong number, you know.
No, they have filed an affidavit in 6474.
7-3 in my.
No, they have corrected it here. 6473.
But in my number, copy one.
No, it is okay, Mr.
Six- six four
No,
seven.
it is. That is
That is
6474.
our confusion. Why they-
Don't be in confusion.
So let's
Unnecessary.
Let file reply, you know, because they have put in the wrong number.
It's okay. 6474.
Okay, I shall file the reply with my reply is ready. So let's 1 week time. That my reply is ready.
You have received the 3 lakhs.
Earlier, 3 lakhs your lordship, I have received, but as per notification, 5 lakhs is entitled.
So you say that you are entitled to not only this 3 lakhs, another 5 lakhs.
5 lakhs, as per their notification,
Another 5 lakhs.
another 5. Then if it is, then let them do, file affidavit.
After I could understand, the situation is something like what we forgetting. At a particular point of time, there is a stream of the government, that 3 lakhs. Whenever it is ended to 5 lakhs, tomorrow it is 10 lakhs, within more than 10 lakhs.
No notification, as per notification, I have.
That is participation in law. So we have to pass on one.
No, his submission is simple. He says 15/11/2014, although say that it shall be only applicable after the notification, but 6/12/2014 notification supersedes all other notifications, and as such, that notification of 15/11/2014 has been superseded. And as such, he is entitled to, without taking into account 15/11/2014. That is his submission.
Because compensation is paid by us, and this guy is paid considering the expense of an incident at a particular point of time. What policy prevails at that point of time?
Understood. Mr. Borpudari understood, but your thing is, your government keeps on paying in such manner. Means you never know. You may be at a later point of time, you may be submitting something which may not be against what the government feels. Isn't it? Understood. That is what I also know till now. Now he has come up with that 1612 because
Therefore, I am submitting, madam. There may be another notification tomorrow, we do not provide. Next year, there may be another notification.
now why 612 was issued? 15/11 categorically say that in supersession of earlier. Now we have any incident happens after 15/11, we are going to give you 5 lakhs. Okay. Now after this, why have you issued 612?
Finance department. By the finance department.
Which one? And the 5/11?
511 is by everyone, but.
So has the finance department filed any affidavit? Why?
Possible kindly, please notification part say, as the mentioned in the attachment. This is only a delegation of powers.
That is what I said also.
But now, possible kindly compare.
Now, why do you use the word in supersession of all earlier orders and in pursuance of the clause 3 of Article 166, that is an executive power, and all powers enabling in this behalf, the Governor of Assam is pleased to direct that the following further amendments shall be made in the Schedule 3 of the delegation of power.
This is delegation of financial power. It does not perceive duty any entitlement. Therefore, possible kindly compare this notification with 15 in November. 15 November notification is specific. 15 November notification counts out minor different categories of incidents against which minor the quantum of compensation is given. It is also very required. This is an internal notification meant for minor the governance of various departments. This is not a general notification. Finance, this is a notification issued by the finance department. Finance department is a nodal department. It only deals with delegation of financial powers. It doesn't give you any right, no right to use from this notification.
Let them to file everything. I shall clear. My reply is clear.
Why
Let them to. I shall file reply. You will. I file.
Not necessary.
My
No,
reply is ready.
whatever may be. But this is very clear. Have you received the 3 lakhs?
3 lakhs, you lordship, earlier, this one I have received the 3 lakhs. 3 lakhs, but subsequent amendment, your lordship,
Amendment of what?
amendment 12,
612.
612.
612 is delegation.
612.
612 is delegation.
Earlier, all earlier notification was superseded.
No,
That is why your lordship, let them to file affidavit in the.
not necessary.
Repetition, they have not filed any reply, affidavit. Affidavit is of it. It's a serious matter, your lordship, let them to file the affidavit, your lordship, I shall file reply, then your lordship will clear the matter. If I am not entitled, then I may be wrong, but as per that notification, I am entitled, your lordship, that is why I am paying. So without record, how the lordship will indicate your lordship, let them to file affidavit in this matter, here. They have not filed till then, your lordship.
No, this affidavit is clear. This affidavit filed by respondent number 2. Respondent number 2's affidavit is
In
clear.
this regard, they have not filed affidavit in my.
No, in 6474, it is clear. Who is appearing in 6474?
6474, I am appearing.
So?
Petitioner.
Yes.
I have the petition.
So 6474, the affidavit is clear.
I shall have, I prepare my reply, your lordship. So let me, one step, I shall file it. My reply is ready.
Okay, file it tomorrow.
Tomorrow, no, day after tomorrow.
Counsel for a petitioner
Day
submits
after tomorrow.
that a reply to the affidavits filed in WPC number 6474/2021 is ready and would be filed by 8/11/2023. List the matter again on 15th of November 2023 for final disposal. Yes. Non-issuance to grant the petitioner society the public distribution license at the earliest. Why? Why do you want the license? So they have not considered your license. Who is appearing for the authority? Huh? Steps no taken. My goodness. All of you are not serious. Hmm? Extra copies have you given or not? No, on 21/6/2023 notice was issued. Then, when did you take steps? Before that, no one would not have any value. You are to take steps. As all the respondents are represented, no formal notice be issued. Mr. So-and-so shall furnish requisite numbers of extra copies of petition along with annexure to Mr. Gugoi and Mrs. Bora within 3 working days from today. Mr. A.D. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that he would take appropriate steps of furnishing extra copies of the requisition, 3 in number. Extra copies of the requisition to Food and Civil Supplies you. You are registered cooperative suppliers. To the learned, to Miss U Das, the learned additional senior government advocate, as well as, what's your name? So and so, the learned standing counsel of the corporation department. During the course of the day, list the matter after 4 weeks.
36.
Same. Not interested, Mr. Chaudhary, you are not interested with your matter. Then, when the order is being passed, why haven't you taken steps? This laxity doesn't show the diligence. What to do? Can't help you. These are small things. I would have directed them to consider and finish it off. You have not taken steps. It's just a simple thing. Your thing is that why you have applied for the license, why haven't you got it? Isn't that? Then this could have been disposed of.
37, 38 orders.
Huh? Why the matter has come up for orders? No affidavit in opposition filed, no affidavit received by the forest department till date. Moreover, no further affidavit has been filed by the deputy commissioner. Huh?
The date of hearing, series has to be a 5 years.
Yes, why no affidavit filed? We impose a cost of 10,000. Huh? Forest department. Who is Miss P. Chaudhary, learned counsel for the forest department?
Pretty, madam, this is a domain of PC. Pollution control board, no.
No, forest department.
Pretty, madam, it's regulated by.
By the impugn letter dated by the through the deputy commissioner so and so shall not be set aside and quashed. And further as to why the petitioner shall not be directed to allow the bill. You are not operating. You have got to stay. How are you operating? If there is a
Interim orders, whereby we are directed to submit certain documents and then to the commissioner to the MSC. And in the other case, we are continuing to pay the royalty and observation.
considering the entirety of the land that they have into the consideration that the deposits were made by the petitioner towards the royalty, I am not inclined to stay the order dated. However, it made clear that any deposit by way of royalty made by the in terms with the letter dated so and so shall be subject to the outcome of so and so. Have been depositing royalty in previous years property. However, it contended here the demand of royalty by Yemen is without any authority of law. So you are paying this 10,000. So you are challenging that imposition of 10,000. Hmm? By a circle officers. And who is paying for the deputy commissioner? Why haven't you filed your affidavit? You are not filing an affidavit. Affidavit filed by respondent number 3. Biswajit Kupon.
they only have to pay the soil. To the review. How the forest. Action they are also to the house.
Show me the impugn letter. Page,
It's 76 of,
page 36,
76.
76. In partial notification of the government circular mentioned above in supersession of all previous government circular with regard to collection of royalty of the, I am directed to inform the government has decided to fix the royalty of brick clean of the state 10,000 per year with effect from 2 September irrespective of the number and the length of PIA. What is the PIA?
Page 76.
Annex P.
Actually,
So government have decided from September 2010. Government means who? Revenue and disaster management. Where is the revenue and disaster management? They are the main people. They are only the executing. Have you made the revenue and disaster management a party? What is he going to do? No. Yeah. Response number 7 is there. Where's the addition? They are the main people. They are, because of them, they are directing.
they, the forest department is also going to take about the real estate from us. The whole issue is that, idea of the there was
No, you are not challenging the forest department's royalty. You are challenging the royalty which is being claimed by the revenue and disaster management. And it is only the circle officer who is acting on the basis of the directions of the revenue and disaster. Now, the revenue and disaster management department is not the same. So we direct the revenue and disaster management department to appear. Yeah. Yes. Why? Why are you charging this 10,000 in excess? They are already paying to the revenue, the forest department. Forest, you are not challenging the forest department. So forest department is out of the picture. We don't require them. You are only challenging what is the authority of the revenue and disaster management to ask for royalty. Yes, Mr. Bhattacharjee, what is your authority?
the other challenge the requirement of the animals
From?
by the by the revenue department.
Show me that.
Page 70. Challenge in the other.
Affidavit filed by respond number 4. Who is the respond number 4? Land policy concern. Yes, now, this permission for NOC is required as per the land policy of 1989, which is also there in the land policy of 2019. Temporary permission for brick, tiles industries in certain government lands only may be given on realization of premium under there. So that is what you say, that it could be on private land.
Also, it's private.
Now you are running.
Yeah.
Because of the order passed by Justice Roy.
We are submitting the other documents that are proved on the municipality, download and certificates and for it and other licenses. What we are submitting.
So all of yours is in private land. Yes. There are two matters. One is, what is your basis of charging the royalty?
It's done by developers. So we have to get a report from how this is done.
No, kindly see page 76. Circle officer has done at your dictates. You see that the document is issued by the Deputy Secretary, Revenue and Disaster Management Department. Page 76 of the amended writ petition. So it is, the petitioner has no objection in paying the royalty under the Mines and Minerals Act to them, to the Forest Department. So the Forest Department is out. Now the question is yours. What is your basis of claiming that royalty from him of 10,000? You have to have a source of power somewhere. That is what. And the other case is, what is your power as regards asking for NOC in respect of private lands? I understand this has a very far-reaching consequences, because without an NOC from the Deputy Commissioner, if it is done, once the pollution gives and the forest gives out there will be no one to check it. So that is another thing where in many cases I have seen the Deputy Commissioner exercising that power. Now this has a very far-reaching consequences again. Now, what is the authority on which the Deputy Commissioner? Yes, for government lands you can, as per 8.1 of the new policy and earlier 8.1 of the old policy. You can. But what about the private lands? These are the beleg order. Others are not required. WPC number 1259/2015. So upon hearing the matter, this court is of the opinion that the stand of the Revenue and Disaster Management Department of the government of Assam would be required as to under what authority they are claiming, they are directing the office establishment of the Deputy Commissioner to collect rupees 10,000 from the bricklings. Mr. A. Bachchanji appearing on behalf of the Revenue and Disaster Management Department seeks for an accommodation of 2 weeks. List the matter again on 22nd of November 2023. 29th of November 2023. The affidavit be filed by 24th of November 2023. Ekon hole etu.
Our name is reflected in the report.
The response number 7 is the Revenue and Disaster Management Department.
Report.
The registry shall also show the name of Mr. A. Bachchanji, the learned as the standing counsel for the Revenue Department in the instant petition. Second column, the instant petition pertains to Econ 5824 of 2014. The instant petition pertains to a challenge made to the authority of the Deputy Commissioner to insist upon a NOC by the bricklanes for running their business. Mrs. Yudas, the learned counsel, additional senior government advocate, seeks for an accommodation of 2 weeks for filing an affidavit as to under what authority the Deputy Commissioner is insisting for a NOC to be issued by his office in respect to bricklanes established in private lands of the petitioners. List the matter again on 29th. List the matter on 29th of November 2023. The affidavit be filed by 24th of November 2023. The respondent, the registry shall show the name of Ms. Yudas appearing on behalf, the learned additional senior government advocate appearing on behalf of the Deputy Commissioner. Deputy Commissioner, which one? Dipu? Dibrugarh.
39.
Yes. Oh, your name? Is the N. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infructuous, and as such, he would not like to press the instant petition. Taking into account the above, the petition stands closed as it has become infructuous. Interim order, if any, stands vacated. You give your names.
40.
Huh? On response number? There's no newly implemented response number 3 here. No implement petition has been received. What are you saying, newly implemented? Don't know. Then what did you do in the Lozima court? The service is complete. I think we have State Bank of India councils. Who is do we have a standing council of the State Bank of India? That Mr. Agarwal, what is his name? Huh? State Bank of India, who appears? Oh, there is another person. No? What is his name? Sahewala. A.H. Sahewala. What is the name? The steps is complete.
Last order, 11/4/23. The last character, the last council for the petition of place for compliance to take instruction regarding the steps to be taken to increase the new income and party respondent.
Why no steps taken? Impose cost. This court, by an order dated 11/4/2023, had categorically observed that without implement of the ARCIL, all caps, the instant retribution cannot be adjudicated. It is also recorded in the said order that the learned counsel for the petitioner sought for time to take instructions regarding steps to be taken to implead the new incumbent as the party respondent. However, the office records reveals that till date no steps have been taken to file an appropriate application seeking implement of the ARCIL. For which the instant petition has been posted before this court for orders. You want time? Cost. This court, Mr. Miss, what's your name? You'll be appearing on behalf of the petitioner, seeks for some more accommodation to implead, to file an application seeking implement of ARCIL. This court grants a further opportunity to the petitioner, subject to deposit of a cost of ₹5,000 before the registry of this court. To list the matter again on 11th of December 2023, it is made clear that if the implement application is not filed in the meantime, this court shall proceed with the instant writ petition. And then make clear that fix the matter again on 11th of December 2023. It is made clear that if the petitioners fail to file an implement application, the petitioner would it is made clear if the petitioner failed to file the appropriate application, the court shall pass appropriate orders on the next stage. Yes, madam. What is the state of affairs? Have you filed any application? No, no. Madam, you get your instructions. Do that. List the matter again on 4th of December 2023. In the meantime, Ms. Yudas, the learned additional senior government advocate, shall apprise this court as regards the settlement proposal. As regards as to whether there has been any settlement proposal for allotment of land in favor of the petitioner. The petitioner, the counsel for the petitioner, further is directed to serve one extra copy of the petition along with the interlocutory application to the Mrs. Yudas during the course of the day.
45.
Huh? You need some time for what? Why the matters come? Let us see. The order of the Lozima Court dated 8/6/2023 reveals that the petitioner is required to take remedial steps for effecting service upon the various respondents. The learned counsel for the petitioner seeks for an accommodation in that regard. List the matter again on 11th of December 2023. In the meantime, the petitioner shall take appropriate steps.
I have one next one. In the Lozama order, let us mention that before that mention 6 and 7 days, respondent number 6 and 7 is used to accept notice that I have and accordingly I my.
Okay, but the remaining some of the people, some are dead. So she has to take remedial steps.
46.
Yes. Substitution of
Respondent number 1. In 2021. Another processing matter and started for the respondents in 25/10/2021. Have to pass. In accordance with the action between 25/7.
when did the respondent number 4 expire?
16/5/2020.
20?
21. 16/5/2020.
And when did you file this application?
25/11/2020.
21. This is an application filed by the petitioner seeking substitution of the legal heirs of legal representatives of the respondent number 4 in the accompanying with petition. From a perusal of the said application, it reveals that the respondent number 4 expired on 16/5/2021, leaving behind the opposite party numbers 4A, 4B, 4C, 4D, 4E. As his legal representatives. steps. The instant application thereupon was filed on 25th of November 2011. 20? 25. 2021. Taking into account that the right to sue against the legal representatives of the respondent number 4 survives upon the opposite party numbers, survives against the opposite party numbers 4A, 4B, 4C, 4D, and 4E. This court substitutes the said opposite parties number 4A, 4B, 4C, 4D, and 4E as against the respondent number 4 in the accompanying writ petition. And they are arrayed as respondent numbers 4A, 4B, 4C, and 4D, and 4E to the accompanying writ petition. The petitioner is directed to file a amended memo of parties before the registry of this court within 7 days. And the registry shall, on the basis of the said amended cause title memo parties, amended memo parties, as well as the instant order, shall make necessary correction in the cause title of the writ petition, accompanying writ petition, as well as also update the same in the CIS. IS stands disposed. A main writ petition, not deputy. Issue notice upon the newly implemented respondent numbers, newly substituted respondent numbers 4A, 4B, 4C, 4D, and 4E by registered post as well as usual. Steps be taken within 7 days. The notice is made returnable on 18th of December 2023. Yes, review. Oh, this one. You want time? You have filed affidavit
No, well, we have prepared something.
because they are bringing in absolutely new facts.
New facts, but these facts doesn't have any connection.
So I can't say that because
I
unless you file an affidavit. I gave you time in the month of August. We are in the month of November.
This, there's some confusion, they need to clear it up, because I had to draft it, the affidavit and instruction I had to, they are not very confused with this review. So I had to look up everything. So now they have officially prepared something and will be filing it in 2 3 weeks. We'll be filing it in 2 3 weeks.
2 3 days.
2 3 weeks.
What day weeks?
2 weeks.
I gave you 5 months, 4 months.
They will change your officers.
What 16/8/2023 this direction was issued.
Yes. but
We are in the month of November. Then
Something is,
what something?
it is very confusing. Madam.
There's nothing confusion. He is bringing in new documents, certain new documents out there. These documents couldn't have been brought in at any point of time. That is your ground of review for dismissal.
Exactly.
Exactly means why are you not filing that affidavit?
It's ready, madam. I have spoken with them.
It's ready now. Why do you need 2 3 days?
Come. Affidavit.
Okay. List the matter again on 29th of November, 29th of November 2023. In the meantime, the petitioner, the respondents are given a further opportunity for filing their reply by 20/11/2023. Yes, what is it? Those are those matters.
48 to 52. I find it.
Yes. So this amount is paid to be payable. So you paid it. How much time? How much? This financial year. No, this financial year. এই পাঁচটা রিভিউ আছে নে কেটা রিভিউ আছে না এটাই হ্যাঁ এই রিভিউ কিটা দিও এটা অর্ডার দিব হ্যাঁ গতিকে এটা এই যে কেটা হ'ল 14 আৰু এটা লাগিব নি 48 we dispose of these review petitions and reopen the writ petitions. We reopen the writ petitions because unless I review it, you're right, you would not get it. So I review the order on the basis of their stand, saying that this other further amount is given, and then fix the writ petitions after 1 month. That is the only way out. Huh? That is the only way out. Your logo writ petition go asan na. Okay. No, it's okay. No, the writ petitions is required. Huh? The 5 review applications herein have been filed seeking review of the order dated 3/3/2023. On the ground that 3/3/2023 passed in WPC number 2808/2021, 4116/2022, 4289/2022, 4099/2022, and 4089/2022. On the ground that the directions which was passed by this court on 3/3/2023, that thereby directing the Assam Small Scale Industries Development Corporation to pay the amount as reflected in the order dated 21/2/2023. had resulted in an error apparent on the face of the records, inasmuch as on a wrong calculation being made by the petitioner, by the counsel for the petitioner, and submitted before this court on 21/2/2023. This court had recorded that the total amount payable to the petitioners was rupees 15,40,000. It is the specific submission of the counsel for the, it is the specific case in the review petition that the 5 petitioners in the writ petitions are entitled to an additional amount of rupees 9,60,470. In addition to the amount of rupees 15,40,000 which the petitioners have already received. This court, by an order dated 14/8/2020, this court had issued notice to the respondents and granted time to the respondents to file affidavit in the matter. It reveals from the affidavit so filed in review petition number 48/2023, and more particularly Annexure A to the said affidavit, that the petitioners are entitled to an amount of are entitled to, the 5 petitioners are entitled to an additional amount of rupees 9,60,470. The respective calculation, which can be seen from the Annexure A to the affidavit filed in review petition number 48/2023, is reproduced hereunder. Taking into account the above, it appears therefore that there was an error apparent on the face of the record in passing the order dated 3/3/2023. And accordingly, the said order dated 3/3/2023 passed in WPC number are reviewed. And the said writ petitions are accordingly restored back to the file. Accordingly, all the 5 writ petitions therefore stands disposed of. Well, it will go next. Econ a pastor writ petition at a common order. Taking into account the order which have been passed in review petitions numbers 48 to Kibera so and so 48/2013 I got to was number Iman and 2 Iman and so Pasca. And the affidavit so filed in review petition number 48/2023, wherein it has been categorically mentioned that the petitioners herein are entitled to a further amount of rupees 9,60,470. The learned counsel appearing on behalf of the respondent, what is that name? Assam?
Assam Small Industries Development.
So and so, 6 for an accommodation of a month so that necessary steps can be taken for dispersing the said amount. List the matter again on 18th of December 2023. On the said date, the learned counsel appearing on behalf of the respondents. On the said date, this court expects that the said amount of rupees 9,60,470 is released to the respective petitioners as per the entitlement which have been duly recorded in Annexure A to the affidavit filed in review petition number 48/2023. List accordingly. On this. A copy of the review petition affidavit. A copy of the affidavit in review petition. The registry is directed to keep a copy of the affidavit. The review petition a copy of the affidavit filed in review petition number 40. The registry is directed to keep a copy of the affidavit of review petition number 48/2023 in the records of WPC number first review petition found there.
Wait, 53.
Yes, Mr. 4 eyes for what? CRP? What is this CRP for? Huh? Seeking review of this court's order.
Division of the appellate order.
No. First and foremost, why is this review petition before this court? Mr. Oscar so-and-so submits that the respondent number who was adjourned had expired on 15. However, nothing has been done in respect to the incident. Accordingly, it stands abated and consequently closed. Petitioner is given to take appropriate steps if so advised. Yes, then? No, it has been closed. Then what have you done?
I've filed this substitution, which was found defective and was taken up.
Why is it before this court? This court has no business to do this with this matter. This is before the
Division.
Understood. I'm not taking a revision, nah. This court is not taking a revision matters. I understand now what you have done is you have cured the defect, which liberty I have given. So you have cured the defect, and as such, you don't require the restoration petition.
It was closed. The division proceeding was closed.
Huh?
Division proceeding was closed.
No, obviously, no, it is not closed. It has abated.
Yes.
You don't require restoration petition for that. Anyways, let it go before the appropriate court. What do you say, Mr. Purkasta? Yes, Mr. Purkasta, what do you say? An application, if a repetition, if a revision application stands abated, it automatically closes by operation of law. You don't require restoration petition. What you require is for a substitution application with a condonation application. That's all. You have to file an setting aside of an abatement. You have to file an application for condonation of delay. You have to file an application for substitution.
Yes, the application which I am calling restoration is an application for setting aside the abatement.
Very well. But let it be before the appropriate bench. Please the matter before the appropriate bench. Not taking up civil bench one for a long time. That is why I asked Mr. Pulkas. What is this? IA for?
I have filed with the wife of the.
Oh, is that the matter where I made you the amicus? Yes, what is your stand? Yes, what is your stand? Last time I have passed an order. Superintendent directed to file the report dated 14/8 along with all its enclosures as well as also submit an updated report of the investigations so carried out. Let me see. We do one thing. You give a copy of this to him. You go through it, then we will take it up on some other day. We will take it up on 21st of November. Upon the, as an admission item, not in the orders. Huh?
Hearing is not.
Oh, hearing, na? Oh, it must be, a rule has been issued. Yeah. Okay, we'll have it on 21st at the top of the list. List the matter on Ms. Yudas appearing, the additional senior government advocate appearing on behalf of the state has submitted a report dated 30/10/2023 before this court. First of all, this court directs Mrs. Yudas to supply a photocopy of this report to Mr. A.K. Pulkas, the learned amicus. First, list the matter again on 21st of November 2023 at the top of the list. The said report so submitted is kept on record and marked with the letter X. We'll go through it then together. What is to be done?
I'm only one solution.
Yes.
I'm regarding at a PET scan. Sometimes, I need some more time to give people. At 10:30 shortly, I cannot hear it. So.
Okay. No, I'm keeping it on top of the list. There is a reason why. Otherwise, this will again come down.